Your Lordship.
Yes.
My lord, this is a condonation matter. Since class 11 months it is not listed. Few days condonation. Opposite party has appeared
When do you want?
on day after tomorrow, my lord.
Okay.
Highly obliged.
Yes.
Lordship, item number 26. Just for justice service report, it may come after vacation.
After
Vacation.
Mr. Argusame, learned counsel for the appellant, press for listening the matter after vacation. Prepare a lot.
May I claim, my lord? My lord, the insurance company deposited 50% amount of the appeal, my lord. My lord, I.
When?
25 11.
When do you want?
My lord, the day after tomorrow, Pay, please, your lordship. I pay for receipt of 3 motion matters on Wednesday, your lordship. Civil revision petition, your lordship. For
When?
motion.
When?
Wednesday, your lordship. Oblige, your lordship.
Lordship. Pertaining to item number 10, Your Lordship, I am taking consent from the other side. Kindly matter may list on 22 January, Your Lordship. I think
You don't.
What is the matter?
Your Lordship, they are challenging Rule 13 of the Assam Service Conduct Rules 1965, Your Lordship. There are similar matter, Your Lordship, regarding which IA in 261523, Your Lordship, that is filed by Mosumi Sohoria versus Srimati Rekha Kalita. Your Lordship, there has been held that if a decision has been obtained without prior permission, Your Lordship, against such a candidate, Your Lordship, misconduct, Your Lordship, there are relevant proceedings of law applicable, Your Lordship. They have not taken consent from the prior Your Lordship, appointing authority.
No. Why you are praying for adjournment?
Your Lordship, here we needed to file our affidavit, Your Lordship. We already obtained instruction.
No. We'll call the matter. We'll call the matter. We'll say. Oh, how many times you have taken adjournment?
Making Lordship.
Yes.
Matter ISCB for release of their own stipulated by the insurance on 19.
May I please, your lord? My lord, I am for item number 18, my lord. This matter may be adjourned for the day, my
Why?
lord. My leading counsel here some problem, my lord. That is the
Mr. Your good name?
SR Borbuya.
Yes, sir. Bormuya, learned counsel for the appellant. Press for listening the matter. When? After vacation. Prepare a lot. Yes.
May I please, Lordship?
Yeah.
My lord, regular second appeal was filed, my lord, on 29th of November, Lordship. May I pray for, my lord, before vacation any day, Lordship? Other side is pressing hard to, my lord. Admission, Lordship. Oblige.
Pray for listing of the transfer matter.
When?
May I pray, madam?
Yeah.
3 MSc appeal, we are not going to press. Can it be listed tomorrow for withdrawal? Like,
I'd like to mention listing of ISCL 2099 of 20. And it's the same matter. And then
When?
tomorrow,
Tomorrow hearing that tomorrow not possible.
yeah.
Okay.
May please, I beg to mention item number 3 and 4, my lord. Matter we are listed after vacation, my lord.
Why?
Counsel for the petitioner is absent today, my lord.
Who is the
After
counsel?
Station, my lord. SB Chaudhary, I on behalf of the SB Chaudhary.
Okay. Your good name?
A.N. Ahmed. My name. SB Chaudhary is the counsel.
No, your name.
Your name.
A.N. Ahmed.
Mr. So learned counsel appearing on behalf of Mrs. S.B. Chaudhary, learned counsel for the petitioner. As for listening the matter. When?
After vacation.
After vacation. Prayer alone. Yes.
The Lord, I take the name to God for the order of the process and that already taken.
When? Pardon? When do you want? 18. Okay, take a date from him.
May I please, Your Lordship? I beg to mention for listing of CRP-IO filing number 14645 for motion tomorrow, Lordship.
Tomorrow is hearing day. Day
Lordship,
after tomorrow.
there is a case in the lower court fixed for a written statement.
Pardon?
Tomorrow in the lower court in Tinsukia, there is a same matter is fixed for written statement tomorrow. Lordship, if possible.
Possible.
Obliged, Lordship.
No, please, Your Lordship. I beg to mention item number 9 may be possible for today.
Item number?
9, Your Lordship. May be possible for today. It listed maybe after vacation, Your Lordship.
Why? Why?
Actually, senior counsel is annual, Your Lordship.
Who is your senior counsel?
Jay Sharma.
Your good name?
A Pator.
Mr. A. Patur, learned counsel appearing on behalf of Mr. Jay Sharma. You inform the other side?
No, Your other side is government, other side education, higher
No,
education.
no, some private respondents are also there. So we'll call the matter.
Master.
May I please, Your I'd like to mention CRP IO 47724 for listing on 18th, Your Honor.
In which column?
In admission, Your Honor,
Admission.
on 19th.
Yes.
Not on CRP Act 34 of 2024 for listing on 20/12/2024 for motion.
Okay.
May I please, Your Lordship? Lordship, item number 39 and 40 hearing item, my lord. These cases are conducted by senior counsel Mr. Z. Kamar, my lord. Since the matter is not fixed today, he has gone through outstation for a case, my lord. He has been appointed amicus curiae. I'm praying it for listing after vacation, my lord.
Your good name?
P.K. Bordelais, my lord.
Mr. P.K. Bordelais, learned counsel for the petitioner. You inform the other side?
Yes, Mr. Goswami is there, my lord.
With consent of the other side, as for listing the matter after?
After 10th of January, my lord.
After vacation. Fair alone.
Highly office.
Yeah, please, sir. Consider the petitioner, my lord. I wish to mention item 36, my lord. This matter will come up on 24th of January, my lord.
Your good name?
Yes, sir. I am appearing for higher education department.
Mr. S. Das, learned standing counsel for the higher education department with consent from the other side, as for listing the matter. What?
24. My lord, we have to receive instruction, my lord. I have not received instruction yet. We need my
When? When do we want?
24.
24. 24th of January.
Time for the petition.
Fair.
May it please, Your Lordship. I beg to mention item number 34, Your Lordship. With the consent of other side, Your Lordship, the matter may be adjourned for today, Your Lordship. And Your Lordship.
Item number 34.
34, Your Lordship.
You are for the petitioner or
I'm from the petitioner side, Your Lordship.
your name?
J.K. Roy, on behalf of R. Sharma, Your Lordship.
Mr. J.K. Roy, learned counsel appearing on behalf of Mr. R. Sharma, learned counsel for the petitioner. No, for the appellant, as for listing the matter.
Lordship,
January 6 to 10.
6 to the 8, Your Lordship. Much obliged, sir.
Thank you for mentioning of the MSc appeal. The matter has been settled between the parties. The matter will come up for orders on Wednesday.
When?
This Wednesday, 18th.
Okay.
19th.
May I please, Your Lordship? I beg to mention for listing an IA in RSA. IA is filed on today, Your Lordship. Filing number we got. And matter may be listed on orders column and order 41.
When do you want?
18.
20, okay.
The Lordship may be finally fixed on 18. On 19, the execution case is fixed on 19.
Okay.
Obliged, Your Lordship.
It is a humble request, indulgence to the court. One second appeal we have filed. There was no urgency in earlier part, but yesterday our client informed that an attempt was made by the plaintiff to dispose her. So without filing any execution. So the Lordship kindly accommodate on tomorrow.
Tomorrow is hearing day. On Wednesday, we'll try.
My personal difficulty is that I'll be out of station from Wednesday. That no, nothing, your lordship will fetch me.
No,
Hello.
anyone can, Mr. Deka can appear on your behalf.
If that try and engage with you, lordship can be my own. Can.
Or you can appear through VC also.
All motion, lordship will take a motion because all hearing matter will be action after the vacation.
Okay, we'll try.
We'll try.
May I please, your lordship, I beg to mention one RFA on Wednesday, lordship. The
In
matter
which
is
column?
urgent. There is a IA, lordship.
In
still
which
vacant.
column?
Yes, lordship.
Order column or hearing column?
Admission, lordship.
Admission.
Yes. 90. Much obliged.
Yes.
In respect of item number 32. With the consent of the other side.
Item number 3.
32, my lord. I pray for an adjournment. I have taken the consent of the other side and for the speech.
Your good name?
D. Chakraborty appearing on behalf of D. Morupa.
Mr. D. Chakraborty, learned counsel for the appellant with concern from the other side, plus for listening the matter. When?
After 2 weeks, my lord.
After 2 weeks. Fair, Lord.
And
You inform the other side?
Yes, but I have taken consent from senior counsel.
Okay.
I'm obliged.
May I please, Lordship? With the concern of others, I beg to mention item number 23, my lord. 23, my lord. This matter after vacation, my lord.
Yes, your good name?
A. Hawari, my lord.
Mr. A. Hawari, learned counsel for the appellant. You inform the other side?
Yes, my lord. BT Deka I have already informed.
With consent from the other side, plus for listening the matter. When?
After vacation, my lord.
After vacation. Fair, Lord.
How like?
May I please your
Yes.
My lord, by this petition, I have challenged the validity of the human order dated 21/5/2024, passed by the learned civil judge number 2, my lord, whereby my petition filed under order 14 rule 5 for amendment of the issues and framing of the issue was rejected. And further, the other petition, which was filed for polling the record, and that was partially allowed, my lord. The lordship will find.
So amendment was allowed?
Not amendment was not allowed. Amendment was not allowed, and further, I also prayed for framing the 2 additional issues. That petition was rejected. And the application which I filed under order to rule 8 for for production of certain documents by the other side, that was partially allowed. Only for the purpose of admission, my lord, may I take your lordship at page 29 of the impugned order. Page, actually, my lord, let us come at page 32, my lord. 32, my lord.
Yes.
Coming to the proposal additional issue, it is seen that the plaintiff has not sought any relief against the dependents regarding misappropriation of funds by the dependents or by the unregistered society. In such a case, the allegation of misappropriation of funds by the dependent is not a matter which requires adjudication, hence does not require framing of any issue in this aspect. A party is not entitled to seek relief that has not been paid for. Regarding the proposed issue number 8, it is seen that the dependent's petition before this court to strike out the related pleadings in para 8 of the plaint, which was registered in this case number 6, para 8 of the plaint, contains the objectionable words alleged to have been uttered by the defendant. This court, after hearing both the sides, allowed the petition by order number such and struck out the derogatory statements from para 8 of the plaint. The plaintiff did not challenge said order, also did not include the proposed issue in the draft issue submitted earlier. With the objectionable word and stem contained in para 8 of the plaint being struck out from the plaint, this matters no longer in controversy between the parties, and therefore there is no requirement of this issue. My lord, so far this finding is concerned, that is the proper finding and wrong finding. Why it is so, my lord? I am taking to your lordship first of all at page 117. That is the order 61, page 117.
Yes.
This is the order, my lord, and last portion of it, page 118. That means that the application was by striking out para 8, and that was allowed by the learned trial court. That was allowed. Subsequently, my lord, I challenged that particular order before this honorable court, and by this subsequent, this honorable court set aside the order that is 6-1, striking out the party, and that order you will find at page 119. And it starts, my lord, this this 11th portion is at page 119.
Yes.
121. 128, my lord. 128, para 40.
Yes.
In the premises, the petition is stands allowed, setting aside the impugned order dated 6/1/22, passed in miscase number with direction to restore the statement government made by the plaintiff herein in Hindi vocabulary in paragraph 8 of the plaintiff to their original form and order. Subsequently, my lord, the trial court, by the order dated next page, 129, they restored paragraph 8, my lord. Pursuant to the order of this honorable court, my lord, those were para 8 of the plaint was restored. 129. 129.
What?
29. By order dated 129. It was restored. By the
129.
Yes.
This order was passed and restored. So in such situation, my lord, the order is absolutely, ultimately wrong order without consideration and without application. On this point, my lord, let the notice of motion be issued to the other side to appear and so forth. And in the meantime, the further proceeding of the suit may kindly be.
Heard Mr. O.P. Gandhi, Learned Counsel for the petition. It is petition under Article 257 of the Constitution of India. The petitioner has put to challenge the correctness or otherwise of the common order dated 21/5/2024 passed by the Learned Civil Judge Senior Division Number 2, Kamrup M. Guwahati, entitled suit number 408 of 2020. Also, it is to be noted here that by the new order dated so and so, the learned trial court has dismissed the petition number 2638 of 2023 filed by the petitioner under order 14 rule 5 CPC for amendment of the issue number 2 and 4 and for framing additional issue
Number 7 and
8. And also dismiss the petition number 2638 of 2023 filed by the petitioner under order 12 rule 8 partially dismiss the petition under order 12 rule 8 read with section 151 CPC for protection of the original documents by the respondents, struck defendants, First, the petition and the documents placed on record, and also for the impugn order dated 21/5/2024. Let notice be issued to the respondents, returnable in 4 weeks. Study taken by registered post with AD and also by the process. Then having considered the submission of learned counsel for the petitioner and also considering the facts and circumstances of the record, operation of the further proceeding or operation of
Further
the order?
proceed-
Further
further
proceeding of the title suit number
408.
408 of 2023 stands state returnable at least after 4 weeks.
Item for admission, item number 2. Pathway matter.
You have already made the filing during the course of the day already.
Today.
Today.
On the last occasion, Lordship has raised a query regarding why innocuous order was passed in the form of a speaking order without elaborating everything. What they say, in the first line, they have said that we have perused the representation as well as all the annexes. It was their understanding. Now, they have given report, their instruction. Even though we have filed one affidavit, I would like to file one additional affidavit. One incriminating affidavit is there. But that document, where the district authority has said that they have got the tax code of 9 and 10. So they ought to have been provincialized. Against that, we sought for a report from the district authority. They submitted that in the record, 910 is not available. This particular is required to be brought to the notice. It goes contrary to what is stated in that annexure. Page 37. You will kindly see. Because this is the main annexure which helps the petitioner to establish that they have a rice code of 9 and 10. And on contrary, now we have got a report on 23/12/2020. And this is dated 13 to 40, 2040. Subsequently, they said no, not there. But you will see page 32. And the third line is so and so is having rice code is having from academic session 9, 10, 10, 11, 11, 12, and 12. As per the Provincialization Act, a school will have to have the rice code of 9 and 10 mandatory. And for not having that, their provincialization was cancelled. And challenging that, they have come before this order. In fact, it is speaking order, which is under challenge in the present petition. There also, we have stated it is not available in the size, which is uploaded, in NIPA format or portal, maintained by the Union of India. It is not available. And so far as this particular document, is an annex at page 18 regarding 9 and 10. Our instruction is that this is the data capture format. It's downloaded, it's after the inserted there. But this particular format will not establish that they have got the dice code in 2009 and that will bring in the record in the additional affidavit. Something lots will have to file.
So when do you?
But I can file it by Wednesday. I prepared it. I can file it today. I will file it by Wednesday. The additional affidavit. All these new things.
So on Friday we will try.
Friday
Yes,
on the reopening. Friday is the last after this. By Wednesday I will file it.
Lordship, with due respect, Lordship, so that procedure, Lordship, record only the 10 minutes proceed, whatever the record proceed, just sent from the elementary department to the Nepal, Lordship, the 10 minutes will require to include the data, Lordship. The document says, Lordship, 37 clear defined, Lordship. The record is available 2019, Lordship. So my friend, council says,
it is not available.
record reflect, Lordship.
Let me place it. It is now.
Let them file.
Yes, yes.
Heard Mr. Arcitas, learned Mr. Gogoi, learned standing counsel for the respondent number
7.
And Mr. Sarma for respondent number 1 to 6. Mr. Gogoi submits that he will file an additional affidavit at price for the matter. So after vacation, on Friday,
Within this week, we will file it, ma'am. On both sides, in the meantime,
Yes,
they can submit
Yes.
a reply also if they
But
want.
the matter we consider for part of lordship.
Yes, it is there.
then price for listing the matter immediately after reopening of the vacation. Mr. Sarma, learned counsel for the respondent number 7 to also submits that he will be filing affidavit in opposition during the course of the day and that call is the matter immediately after reopening vacation. Where along it is the matter on when? 3rd of January?
Well, around
8.
Yes, sir.
8. Okay. As part of it.
Part, yes. Mass obliged.
Number 5.
Yeah, we have received Paravai's report lordship. First, allow 1 week. We'll find.
Lordship,
Lordship may fix immediately after.
it is a case of, originally it is a case of 2012 Lordship. And followed
2012.
by Lordship. Actually, this is the third round of litigation Lordship. Followed by an order passed in my contempt petition Lordship. I have challenged the speaking order Lordship here.
Only pass. Lordship will allow. We have received the instruction.
Third, Mr. Rio, good night.
H. Talukdar Lordship.
Case,
Talukdar Lordship.
learned counsel for the petitioner and Mr. Sarma, learned counsel for the state justice. Mr. Sarma submits that he has received Paravai and price for this matter after vacation. Then?
Lordship.
After vacation, so as never to file affidavit in opposition. Fair is accordingly allowed. This is the matter immediately after reopening the vacation.
Obliged Lordship.
Item number 6.
Lordship, as per last order, there is 2011-2024.
Yes.
Lordship has decided to dispose this matter without affidavit if it is not filed. Last chance has been given. 2011-2024.
Yes.
Lordship got it?
Yes, got it.
In this case, basically, petitioner herein is a teacher.
But Mr. Goswami, who is for the PTC?
S.R. Rabha was appearing. Basically, this case is covered by a Lordship judgment. Lordship has already decided in another case regarding Lordship the entitlement of the pension. Here we are claiming we are appointed before 2003 and we have been Lordship, our service has been twice regularized. They have terminated the service and termination was set aside by this honorable court. And thereafter we have been reinstated. Now they want to give us, Lordship, new pension scheme. They want to give us new pension scheme. Here, Lordship,
Originally, we have been appointed in the year
99.
99. Yes.
They have issued a notice terminating our service. That order has been set aside by this honorable court. Hereafter, they have said that they will regularize their service. And accordingly, they have regularized our service. After regulation, Lordship will find the regulation order as per order of the honorable court. We have completed, we have the GPF account, page 36. Lordship will in page 36.
Earlier, you have been allotted GPF account.
Lordship, page 36. Page 36 is a GPF account, statement of GPF account, 7/8/2001. Lordship got it?
Yes.
This is GPF account. Rupak Kolita.
Yes. Then subsequently, what happened after termination
Subsequently,
of their, termination, no, after
Lordship will find
after crossing
at
of
page
the
40, at page 40,
40.
Lordship, service has been terminated.
Then the said order was
Set aside.
set aside. And you have been reinstated.
Set
by-
aside page
Huh?
42. Page 46, the relevant post order. Page 46, the relevant order.
Yeah.
Para 3. Petitioner who had not been paid their salary for their period of service they have rendered shall be paid their salary seeking budgetary allocation, which BTC authority has already written to the government. Necessary budget sanctions shall be provided by the government to the BTC towards payment of the admissible salary of the petitioner who have not been paid their salary. It is made clear that such payment of salary of the petitioner will not be dependent on the interim order passed by this honorable court, meaning thereby that irrespective of interim order passed by the petitioner shall be paid their salary. They are in tune of the interim order passed on Iman. Writ petition are disposed of. Hereafter, Lordship will find another writ appeal has been filed by some of the petitioners, where government has said page 81.
Page?
Page 51.
Yes.
Lordship will find page 51.
Yes.
Fourth paragraph. Counsel for the BTC submits that a policy decision has been taken that a person receiving regular salary from the month of 2006 would be regularized, and implementation of the policy is in process. Government of Assam has also agreed to the said policy. In view of the above submission, writ petition are disposed of with the direction to respondent to effect regulation as per policy decision of all eligible teachers who were regularly receiving salary up to 2006, 17 and 2006. Lordship, thereafter, page 55.
Page 50. Into the termination.
Before the page 54, Lordship. Page 54 dated 22nd September 2015.
Yes.
In pursuance to the Bodoland Territorial Council Executive Meeting Resolution number Iman, Resolution number 4, minutes of the departmental meeting, Education Department Iman respectively, the Bodoland Territorial Council is pleased to withdraw the termination order dated 6/11/2008 against Rupak Kolita, assistant teacher of Borbila Giant High School in terms of Director of Education Assam, ordered with prospective effect. Prospective effect. Now, Lordship will find page 55. This is regulation order again. In pursuance to the Honorable High Court's order.
Mr. Goswami, you tell me this prospective effect. It means earlier services were not counted.
There is an order from this Honorable Court to give all salary during pendency. Against that order, they have not preferred appeal, nothing. So we are entitled for salary, everything. As per order of this Honorable Court, they have passed this order. This is a surprise case. Lordship will find page 1, October 2015. Regulation order again. Page 55.
Yes.
Now, Lordship did Rupak Kolita, who was terminated from service by order dated Iman, from which he hereby withdrawn, and his service is regularized, reinstated as assistant teacher Iman, other admissible allowances as admissible under the existing government rules. Lordship got it. Thereafter, petitioner has joined in the school again. Page 56.
Yes.
Secondly, Lordship again find page 57. Second regulation order. 30th September.
Why there is second regulation?
That is, we are surprised, Lordship. How they have doing all these things, we do not know. In excess of power conferred under Director of Secretariation and pursuant to approval of BTC, Assam communicated that Iman, Rupak Kolita, who was reinstated in service had ordered that Iman from the end of the hereby regularization sir, is in the scale of pay Iman, the get pay Iman and other allowances admissible existing government rules posted in Iman and regulation order shall come into force with prospective effect again. Second regulation order.
Is there any difference between the two orders?
No, same thing.
Same thing.
Same thing. Only to deny our pensionary benefit. Because we are appointed in 1999, we are getting regular scale of pay after completion of basic training. After completion of basic training, we are given the regular scale of pay. Hereafter, Lordship, they have terminated service. Termination has been set aside by this Honorable Court, directing the pay, all the pay salary allowances. Thereafter, they have
And the past salary was given to you?
Past salary is not paid.
Not paid.
Not paid.
In spite of order of this
order of this Honorable Court. Contempt petition is pending regarding that order. Now, Lordship, we claim that we have to give in the pensionary benefit as we are entitled under old pension scheme. And similar situation, Lordship has directed to give pension. Those are appointed in 2003. We are appointed in 1999. And our service, Lordship will find another thing. We are not illegal teachers. They have given a report. Lordship will kindly see.
Page number.
Page 52.
Yes.
That is a letter from the Director of Education, Bodoland Territorial Council, Kokrajhar, to the Secretary, Education Department, Bodoland Territorial Council. Submission of report. With reference to the subject cited above, I have the honor to state that as per report submitted by DODI, Nalbari, reference connection to the appointment of 259 of out of 269 of who were appointed in the middle and primary school during year 1999 and adjusted against valid sanction post retained permanently by later dated Iman. 259 of teachers included in the list of 2272 doubtful teachers declared and published by the government of Assam. Our list has been included with the excess teachers, doubtful teachers. It is hereby clarified that as per order dated 14/2005, government has considered for release of salary who had been drawing salary regularizing up to 17/10/2006 would be only entitled to draw their salary as per record of BO Treasury, Nalbari. All 259 of teachers are drawing their salary prior to 17/10/2006. It is pertinent to mention here that service of 259 of out of 267 have been terminated as per order of the Secretary BTC during 2008-9. Therefore, I would like to submit here with their representation that demand in connection with the withdrawal of termination order and reinstatement of service in favor of your kind consideration and necessary action. Now, the teachers who were regularly appointed, page 53. Petition number 1, Rupak Kolita. So you will find detailed report of 51 LP student teacher BO Tamulpur who drawn salary, monthly salary prior to 17/10/2006, Rupak Kolita. Our name has been included with the excess teachers or illegal so-called terminated teachers, and thereafter our service is wrongly terminated. And thereafter everything has been regularized twice. I do not know how they have regularized twice the service of the petition.
Yes. Mr. P. Chaudhary, Delhi Council, the Department of Police Policy. Oh, P. Chaudhary. Yes, he's appearing in this matter. He's occupying another combatant. Okay. Let him appear before this court after some time. Otherwise, my lord, we have visited our para with the comment. So,
2011-2024.
yes. Last that it has been clarified that no further time will be given to you. My lord, then let's move to the other. Okay. Okay, Mr. Gupta.
Mr. Padanik.
Item 7.
May I please, Lordship?
Yes.
Lordship, appeal under section 23 of Railway Claims Tribunal Act, Lordship, against a judgment and order passed by the member of Railway Claim Tribunals, whereby the claim of the applicant has been dismissed, Lordship. Lordship, applicant prepared the aforesaid claim petition under section 16 of Railway Claim Tribunals Act. Before the Railway Claim Tribunals, Guwahati, preparing for compensation of 8 lakhs on account of death of son of the applicant, Lordship.
Okay. Third, Miss
P. Udhigari.
Learned Counsel for the appellant. This appeal under Article 23 of the Railway Claims Tribunal Act 1987 is directed against the judgment and order dated 28/6/2024, passed in claim application number OAIIU-12 2023, passed by the learned member, Railway Claims Tribunal, Guwahati. Is to be noted here that I did judgment and order dated so the learned tribunal has dismissed the claim of the appellant. Peruse the memo of appeal and the grounds mentioned therein, also peruse the judgment and award dated so. Admit, issue notice to the respondents returnable in 4 weeks, that be taken by the third with ADM vehicle process. Today. What was the claim?
Claim, Lordship, earlier Lordship tribunal has been dismissed, Lordship, our claim.
No, why the claim petition was papered?
Claim petition, Lordship, page 9.
Page number?
Page 9.
It's to be noted there that by the judgment report of judgment and order dated. Tribunal has dismissed the claim petition filed by the appellant on account of death of his son, namely Tamizur Rahman, on 11/11/2022, while he was proceeding from home to Guwahati for some walks and meet with an accident. And returning home in train number 05605 UP. Up Sokubi. Just before reaching Jamunamukh, in between Kanpur and Jamunamukh railway station, at railway camp number 128/5-6. By registered post with 18 also by the process today. Call for the record from the learned tribunal, place the matter after 4 weeks.
Number 8.
Wait, please, Lordship. They challenge the impure order, judgment and order Lordship, I've taken the step of only one is appeared. There is a delay. I've taken the step of delay 1, 2, and 3. It is reflecting the delay petition 2 and 3 also received. It is there is a big order.
So delay is yet to be confirmed.
Delay is already condoned.
Condoned.
Condoned or receipt of the notice from this honorable court, but they did not appear. Delay
So
was condoned.
you are appearing for?
No, one
One,
A
one.
and one B. Payment.
So, my lord, in this case,
Yes.
we have challenged the quantum as well as the ration negligence between the vehicle, motorcycle, and the cruiser. The cruiser is being the made as an offending vehicle. There is a head-on collision. So we have challenged the two modes. Two ways. One is quantum and another causal accident. So maybe I'm allowed to 14 lakhs I'll pay in the income. Out of 29 lakhs, something is done. Because there is a no proof of his salary. This is salary. They have given some document, but the author has not come that it is the document furnished by this that company.
What is the total quantum?
29 lakhs odd. They're ready to pay 14 lakhs.
Heard Mr. R.C. Pal, learned counsel for Dhaka. Then also heard Mr.
M.
Talukar, learned counsel for the respondent number 1A2.
1A and 1B.
1A and 1B. This appeal under section 173 is directed against the judgment and awarded at 22/12/2023 passed by the learned member, Motor Accident Claim Tribunal, put in bracket, MSCT, Kasar Silsor in MSC case number 602 of 2020. Full stop. It is to be noted here that by the impugn judgment and award dated 22/12/2023, the learned member MSCP Kasar Silsor has directed the appellant herein to pay a sum of rupees 29,35,561 rupees within 30 days from the date of judgment and award, along with interest at the rate of 7% per annum from the date of filing of the claim petition, that is 10/11/2020, till realization. Where is the memo of appeal and the grounds mentioned therein? Admit. Issue notice returnable in 4 weeks. However, no formal notice is required to be issued to respondent number 1A to 1B, since Mr. Talukar has appeared and received notice on their behalf. However, extra requisite copy of the petition
Hello, already furnished. Copy is furnished. Extra copy already furnished.
State upon respondent number 2 and 3 be taken by registered post with AD and also particular process. Shall call for the record from the learned tribunal. Is the matter referred for it. Is there any IA?
Yes, ma'am. I is my lord 12866.
So 50% of the awarded amount within
14 lakhs maybe.
50% around
50%.
14 lakhs. 50% maybe.
50%.
50%.
Maybe. My lord.
50%.
Within my lord
2 weeks from today?
My lord?
Within 2 weeks.
2 weeks it's not possible. It will be closed, my lord. I'll not be here.
Okay, 3 weeks.
My lord, 4 weeks given.
No.
Because I have to get this order copy, then I have to furnish, then company.
You can send the copy by evening today.
My lord, at least give 4 weeks, my lord.
No, 3 weeks.
Payments will be allowed to be processed.
Okay. Appellants may be allowed, the respondent number 1 may be allowed to withdraw the amount fully.
What number? 5.
Before the receipt of the report.
5.
Yeah, please, Your Lordship.
Yes.
My matter may be possible for today, Your Lordship. Consent was taken,
Consent
yes,
was
sir.
taken in the morning.
Consent.
Consent was taken in the.
The appear being made by Mr.
A. Pator on behalf of Jay Sharma.
A. Patur, learned counsel appearing on behalf of Mr. Jay Sharma, learned counsel for the petitioner raises unless the matter when
After vacation?
after vacation.
Highly okay.
Numbers 10 to 13.
In item number 11, my lord, readings are complete, my lord, but in other cases, item number 10, they have not filed affidavit.
Early morning, your lordship, I may mention your lordship regarding item number 3. During your lordship instruction received your lordship. I need some time, your lordship, 1 week time.
Item number 10.
10.
No, he has submitted the pleadings complete.
In item number 11.
11.
11.
Affidavit has
Not 10. On the appear being made by Ms. Peters, learned counsel for the respondent. Authorities with consent for the other side. Raises list the matter when
My lord, on first week of January, my lord,
First week of January.
on 9th of January, my lord.
on 9th of January, so it's to enable the court file affidavit in opposition. In item number 11,
Pleadings are complete, my lord. It may come on 9th also, my lord.
9.
9. Issue is same, my lord. They have not given the charge of the principal of the higher secondary school to the
But
my
they
lord.
have challenged the show cause notice.
Whatever. It was just
Part Mr.
be protest.
People also learned counsel for the petition. He does learn it. Counsel for the respondent purpose. They submitted at the bar that the pleadings already completed and the matter is ready for admission hearing.
Admission.
Place the matter on 9.
9-1.
In other two matters,
Same, it's same petitioner, it's the same by.
okay.
All are
On
connected.
9 then,
9. my lord.
same order.
Keep your.
14.
This matter is relating to selection and appointment of grade 4 employee lordship. My grade 4
Grade
employee.
4?
Grade 4 employee in a higher secondary school. My lord, I was top in the select list. Second and third appointed. I have not been appointed on the ground that there was no retention of the post. Proposal was submitted to the government lordship. That has not been lordship yet to be considered. That has not. Only short issue is involved because already proposal is given lordship by the inspector of school. They have to accord the approval lordship. After that, he will get appointment. Page 36 is the
Page
proposal.
36, the lordship will allow me to give instructions on this because the proposal was sent to the director of secondary education for retention of the.
So next Friday. Third, Mr. M. Khan, learned for the petitioner, and Mr. Musa Hari, learned for the secondary education. Ms. Musa Hari, learned counsel for the respondent on purpose and instructions are everything. They may be done with some time. There is allowed. Raises at least the matter on Friday.
Blessed.
Item 15.
But present. By the earlier order dated, my lord, this court directed them to, my lord, file the affidavit and also produce the records, my lord, order dated 4/11/2024. The case is very simple in the sense, my lord, due to non-provincialization of the or the delay in, my lord, provincialization of the service of the petitioner, they had approached this court. And this court directed that to consider their case and to provincialize the services. Accordingly, state level selection committee, they have said and they have recommended for provincialization of the teaching and non-teaching staff of the school along with the petition.
This selection was challenged by one of the persons before this honorable court. And this court having found that against such order, appeal is maintainable. So directed them to file an appeal before the state government. And the state government was directed to dispose of the entire things within a period of 1 month. And till then, the provincialization so far as petitioner and another is concerned, directed to be state. So this period is only for a period of 1 month. And it is subject to the condition that the writ petitioner of that writ petition should file an appeal before the authority. Now, no appeal has been filed, and the authority could not consider the same. So therefore, we have approached this court by filing a contempt petition. And thereafter, pursuant to the earlier order of the High Court, as well as the contempt order and the notice in the contempt, they have sought for sanction of the so far as the other stuffs are concerned, they have so far as the petitioner and another was concerned, they were kept out.
They were kept
out. So far as I am and the another, as the writ petition filed by the another person challenging the recommendation of the state level selection committee was disposed of, directing the writ petitioner to approach the authority by filing an appeal. And the authority was directed to dispose of such appeal in case it is filed within a period of 1 month. And till then, the provincialization of the petitioner and the another should not be materialized. Now, no appeal was filed. 1 month has elapsed. Rather, much more time has elapsed. So we have approached this court by filing a contempt petition. Now, pursuant to the earlier order passed by the High Court in our favor for provincialization, as well as the notice on the contempt, they have taken up the matter. And the resolution that has been taken, that has been approved, they have sanctioned the post. Out of the 11 posts, which included me, they have sanctioned only 9 and kept me and the another person out of the provincialization because of the order dated 18/7/22, which said that this provincialization of the petitioner and another should not be made for a period of only 1 month. That they have been unilaterally continuing that. So since the 1 month has elapsed from the date of the order dated 18/7/2022, there was no embargo on the authority to provincialize all the employees, including the petitioners. But they have done only in respect of me and the so far as the others have been done, so far as me and the another, they have been kept out. The Lordship will kindly see the order at page.
No, anyway, madam, have you filed your counter affidavit?
Your Lordship, on the last occasion, 4/11/2024, Your Lordship, matter has been listed, Your Lordship. But our to file counter affidavit, Your Lordship, 4 weeks time granted, Your Lordship, but instructions awaited, Your Lordship. And it brought us 2 weeks time, Your Lordship, to file our.
No.
The motion matter, Your Lordship, on the last occasion is since the second time, Your Lordship, this matter has been listed. No notice has been issued.
So if second time is not enough, how many times you require?
Notice, let the notice make.
No, issue. Notice has been issued.
One last time, Your Lordship, Your Lordship, to obtain instruction, Your Lordship. Without instruction, Your Lordship, it is difficult for us. Right?
So general passing.
Lordship. By the earlier order, Lordship was directed to produce the record also, to see whether any appeal is filed and whether any proceeding was initiated. So records,
Your Lordship, by filing affidavit, Your Lordship.
the original record is also needed, my lord.
You produce the original record,
It
you
is already
provide the order dated 4/11/2020.
Lordship.
Departments of Business Circle, learned petitioner and speeders, learned also for the respondent authority. Speeders, learned also for the respondents of that instructions are awaited and price for granting are 2 weeks time. Here is allowed. Raises the list of matter in first week of January. Then on that day, fix a date. Short date. 6th of January. On that day, as per order dated 4/11/2024, the Ms. Das shall produce the record. As pulp of high order dated 4/11/2024.
Your Lordship, can it be on 10th, Your Lordship?
No, no,
46
no,
and
no.
9, your lordship, some matter has fixed, your lordship.
Maybe.
Item 16.
My lordship, kindly pass about the matter for time being,
Okay. Why?
because SP Sodri sir he's coming. Okay.
File our affidavit.
When?
We filed our affidavit on 28th of November, lordship. But as to file reply of 28th of November. By restaurant number 1.
Good.
The reply has also been received. Okay, after some time.
Item 41.
So we will file a reply. They file
You have not
today.
yet filed.
No, they have filed today. They will
Today.
file today.
Okay. Third, Mr. Ali, learned counsel for the petitioner, and Mr. D. Upamanya, learned counsel, standing counsel for the higher education department. Mr. Upamanya submits that he has filed his affidavit in opposition to the morning. Mr. Ali, learned counsel for the petitioner, submits that he will file reply to the affidavit in opposition filed by Mr. D. Upamanya, learned standing counsel for the respondent number. For the higher education department, respondent number 1 and 2. List the matter when
2 weeks, your lordship.
after 2 weeks.
For hearing under order 41, go to CPC. Item 17.
May I please, Your Lordship?
Yes.
There are concurrent findings against me, both the court below. In the suit, I am the defendant, and respondent are the plaintiff, Lordship. They have filed a suit for declaration of right title interest and subsequently amended the claim and for recovery of possession. What happened, Lordship? One Gulabuddin Munshi and Gulam Haq, both are brothers, are the possessor and owner of a total land, about 4 acres, 1 quadrant, 4 acres of land.
So judgment was delivered in the year 2014.
Lordship, what happened, Lordship? In this case, Mr. G.P. Homik, learned senior counsel, was engaged earlier.
Who?
G.P. Homik, learned senior counsel.
Yes.
His health is not well, Lordship, and there are some limitation petition there is pending. That's why he has been some delay.
Limitation condon.
Condon, Lordship.
Yes.
One Gulab, I am the defendant, Lordship, in the main suit, and the respondent are the plaintiffs. One Gulabuddin Munshi and Gulam Haq are the joint owners. They are the brothers of total land 4 acres, 1 quadrant, 4 acres, Lordship. And one Ghafiruddin Mondal. Now this is, Lordship, the predecessor interest of the defendants, appellant hearing. They purchased the land from them, both Schedule A and B land, Lordship, in the year 1988. And after, for a consideration of rupees 12 lakh per bigha. And since then, they have been possessing the land. But at that time, Lordship, registration was banned from the Assam government, for which no sale deed has been executed. But they are in possession of the land. From 1988, subsequently, their name has been mutated in the year 1988. In the main suit, Lordship,
That's right. You come to the memo of appeal.
Yes, Lordship.
It starts from page number 1.
Page number 1, Lordship.
So where is the
Substantial question of law has been filed separately, Lordship.
When?
I think on the first page, Lordship. Yeah, before the memo of appeal.
But it should be part of the memo of appeal.
Yes, Lord. But because the case has been filed by
You have to mention it in the memo of appeal itself.
some cases.
You see subsection 3 to section 100.
Yes, Lordship, that is right. The case has been
You
filed.
file amended memo of appeal. Third, Mr.
D. Kolita, Lordship.
Learned counsel for the appellant. Leaves the matter in the first week of January. So as to enable Mr. Kolita to file amended memo of appeal incorporating the suggested substantial question of law. Please record it.
Oblige, Lord.
Item 19.
Another court. After some time. Or at 2 p.m.
At 2 p.m. At 2 p.m. Huh? At 2 p.m. After 15 minutes, my lord.
After some time, okay.
After some time.
Number 20 matters for orders.
There is a not the implementation of order passed by this honorable court in January 2020, 19, Malad. The Annex A is the order, Malad. 22/1/2019, Malad.
State has filed already IA and IA for condonation of delay and appeal, my lord, for appeal. Because, my lord, it is Act under 2011 Act and it is not implementable as because, my lord, it is already struck down, my lord. So state has preferred, my lord, appeal.
This is a contempt petition, Malad. They have yet to file their affidavit in opposition here, Malad. Malad, contempt means they are violating the court's order. Their excuse is by verbally, it is informed before the honorable court, they preferred an appeal with a delay more than 5 years, Malad. There is no stay order, meaning thereby there is no impediment, Malad. It's required to be implemented, Malad. They have not obtained any protection before the appellate court, Malad. So, my respectful submission, since they disregard the order passed by this honorable court, not even they want to file any affidavit, Malad. This petition has a filed way back in 2020. Malad, still the order has not been implemented. That is why my Malad, humble prayer for Lordship, Malad. Some order may pass, Malad, against that, Malad, Malad, draw up the contempt of court proceeding against the official respondent. That means present the commissioner and the director, Malad.
My lord, in this matter, we want to file affidavit, my lord, and my lord, it was handled by the NJ Khatania. My lord, his mother is seriously ill, my lord. So he is out of station, my lord. So, my lord, sometime may be granted, and in the meantime, we will.
No, it's a contempt proceeding. If other day also he took time due to his absence, council absence. Admittedly, I will definitely accept that council difficulty, but always I cannot, my lord. I have some pressure, my lord. Definitely, my lord, these honorable court rightly pass an order that has yet to be implemented. They are violating the court's order.
My lord, already this.
They don't even bother to file an affidavit till date, my lord.
So, my lord, sometime may be granted, so that we can file our affidavit, my lord.
Here the time is also, my lord, essence, my lord. More than 5 years elapsed, my lord. Even, my lord, this honorable court's order has been implemented, my lord. Could not.
Could a notice upon respondent number 7 and 8 expected?
My lord, the attorney's name is Sohn, my lord.
It's a Catonier.
But this mother is seriously ill, we out of station, my lord.
So, we are granting you last opportunity. You file affidavit.
My lord, definitely, in view of the council, my lord, difficulty, I always accept. Other day also, not if specific date may be fixed, my lord.
Okay. Third Minister A.K. Goswami, Lord and Sir.
Which one?
You, Sharma, Lord and Council, appearing on behalf of the S.A. Khatapir, Lord and Council for Order 7. Whether he has been representing respondent number 8 also?
No.
No. None appears for the respondent number 8. Mr. U. Sharma, Lord and Council, appearing on behalf of Lord N.J. Khatapir, Lord and Council for the respondent of time to us to file the affidavit. PLD is accordingly allowed. Please matter on.
I am for the respondent number 7, madam.
My lord, highly obliged, my lord.
8 of January. It is being clarified that no further opportunity will be granted to the respondent number 7 to file affidavit.
21.
May it please your lordship.
Yes.
Lordship, as per office note dated 25/11/24, respond number 1 service is complete, lordship, as it has been received by the wife. But respond number 2 could not be served as he could not be found in the address. So lordship may allow us to take steps upon him by way of paper publication, lordship.
Right?
Paper publication in a vernacular newspaper because it's Nagaon address.
Heard me, sir?
SP Sharma, lordship.
SP Sharma, Learned Counsel for the appellant. Office note dated 25/11/2024 indicates that notice upon respondent number 2 notice upon respondent number 1 has been served, and wife of the said respondent has received the notice. Office note dated 25/11/2024 also indicates that service report in respect of respondent number 2 has returned with the report that the person concerned could not be found out in the given address. The learned counsel for the appellant submits that he may be allowed to cause service of notice upon the respondent number 2 by substituted note by paper publication. Here is accordingly allowed. After publication of the notice into widely circulated papers, the locality of the respondent number 2, the counsel for the petitioner shall file an affidavit before this court, including the papers. List the matter after.
Lordship may fix a date or lordship may list this matter in the month of February, lordship.
After 4 weeks.
Obliged.
52.
May it pleases your honor, as per office note dated 27/8/24, unserved notices has been received back as on respondent number 5 and 6. And they allow us to take fresh steps upon them, your honor. And respondent number 11 expired, your honor. To that effect, we'll file appropriate application.
Heard, miss?
I'm not, your honor.
Learned counsel for the appellant. And your good name? Ms. Dave Sen, learned counsel, appearing on behalf of Mr. J. Ahmed, learned counsel for the respondent number 120. Office note dated 27/8/2024 indicates that service upon respondent number 4, 7, 9, 10, 12, 13, 14, and 15 are duly effective. And said office note also indicates that notice upon respondent number 5 and 6 could not be effected as they could not be found out. The learned counsel for the appellant submits that she will take fresh step upon the respondent number 5 and 6. Office note dated 27/8/2024 also indicates that respondent number 11 suffered demise. The counsel for the appellant submits that she will take necessary steps for impeding the legal heirs of the respondent number 11 and price for granting her some time. Here is allowed based upon this matter after 4 weeks.
Much obliged.
24.
So we have already compared the order, we have issued a compliance order. Take one video. Direction was to file a representation lawsuit. It was filed by the petitioner. It was considered by the director of secondary education and rejecting the claim of the petitioner office. On the ground that her name was recommended against that there are 4 enrollment of the students. and for which her motion for a third post could not be considered.
Yes.
Yes, my lords of earlier date, honorable court. Give instruction from my client. I have not received the instruction earlier date.
Yes.
So let the matter wait after vacation.
So we have already complied with that. There's no.
No, earlier date, honorable court passed the order, received the instruction from my client. I have not received my lordship till now.
That's
So
not
let the
necessary
matter
right
after
now.
vacation.
Because I have given a compliance order that can create so content will be closed. Also. He may get and may not get the instruction from his client. That is not necessary. The direction to the national authority to consider his dependency. So we have considered, we have rejected it.
Anyway, let him obtain it. Next day we will close the matter. Third Mr.
In Islam.
Learned counsel for the petitioner and Mr. Sisti, learned counsel for the counsel for the contempt. Standing counsel for the contempt. Mr. Sisti, learned counsel for the contempt, has produced a order dated 5/10/2023. Passed by the Director of Secondary Education and before this court and submits that the order of this court has been complied. The learned counsel for the petitioner submits that he has not received the instruction from the petitioner and tries for granting him some time where is allowed to settle with the matter on accepted 10th of January.
Obliged.
25.
Maybe stay. For the responder, I am led by James Hayawala, sir, senior advocate. But he suddenly fell unwell in the court itself and he has been hospitalized.
Okay. As read for by Mr.
And Sharma.
Learned counsel appearing on behalf of Mr. T. N. Sayola, learned senior counsel for the respondent number 1. The registrar lists the matter when? After vacation.
All right.
27.
May I please, Lordship? The LCR is awaited in this appeal. I'm not sure. As per order dated 2/8/24, LCR was called. Not been seen in the.
No, LCR has already been received.
Then
Hearing. Both the parties are represented by their NDA counsel. Office note dated 21/9/2022 indicates that LCR has already been received by the section. And as the matter has been ready for hearing, the learned counsel for both the parties press for listing the matter for hearing. Accordingly, it is provided that this is the list the matter for hearing in usual course.
What's up? Interim protection may be continued.
Pardon?
Interim protection may be continued.
Interim
IA is
is there.
there. IA is there for 3. Interim is there.
No, there is no interim.
It is there, Lordship, perhaps. It is there.
Okay, it is in main case. The interim order passed earlier shall contact.
Deeply.
28.
May I please, Your Lordship?
Yes.
As per office note dated 1/10/2024, my lord, service upon respondent number 5 and 6 is completed. LCR also received, my lord. Lordship may fix this matter for hearing in UP.
Okay. Both the parties are represented by their in this. Madam, you have for respondent number two. Respondent number two. Madam, Burman for respondent number two. But the record was received.
Receive, yes. Office note dated, my lord, 1/10/2024.
Okay.
It has been reflected, my lord. 1/10/2024.
Office note dated 1/10/2024 indicates that service upon respondent number 5 and 6 are provided, but none appears for them. But no one represents them.
5, my lord, Okalatnama has filed. Them as shown in the cause list.
Why? Though Wakalatnama has been filed by one advocate, namely
5. Name, my lord,
P. Majumdar and R. Sarkar. Said office note also indicates that LTR has already been received by the section. As the matter is ready for hearing, let's establish the matter for hearing in legal course.
obliged.
29.
May I please, your lordship?
Yes.
My lord, this petition, interlocutory application 3224 was filed by the respondent. For modification of the order passed in this revision petition, it is at page 121.
Dated?
Page 121. This order was passed by Honorable Justice P.J. Saikia.
Yes.
So the modification or review
Has to be done by that court.
by that.
I have a problem here. In the name of that, your lordship, for 1 month, your lordship, it is listed to defend honorable benches.
Specific
there
order
must
may be
some
passed.
Specific order may be passed, and moreover, your lordship, the problem we are facing, on the basis of that judgment, your order, your lordship, passed the honorable court, your lordship, they have taken the position, and now what is saying, suit is pending, wherein I filed the suit, he is not in a position, it is admitted position, even if by filing WL. But because of that orders, the position was given to him. What he is doing now, he has filed 2 cases for judgment of my term.
All
On
these
the state of
cases,
daughter.
all these matters will
On
be
the state
mentioned
of
before the
daughter, no.
appropriate bench.
On the state of daughter.
Okay.
Not before this court.
No, your lordship. One thing, my humble submission, your lordship, and another thing, what they are doing, your lordship, because of this the order, your lordship, they are advertising before the market, you have to sell.
That's all right.
So my humble submission, your lordship, till then, let this may be protected by this may be sent to the relevant bench, your lordship, honorable bench, your lordship. But till then, your lordship, a status quo may be passed so that he cannot sell and alienate and do anything, your lordship. That may be done, your lordship. What harm will be happen to him? That order will be passed.
That order cannot be passed. Moreover, there is no prayer, such prayer in the petition.
There was no such prayer in the trial court, your lordship. Still that order obtained by the learned friend, your lordship. In the trial court, there is no suit, there is no contract claim, no order, no prayer, your lordship, and mandatory injunction obtained.
You raise the issue before the
appropriate bench. Appropriate
Sir S.C. Sharma, learned senior.
I only submitted accepted.
And Brahmal.
And also heard Mr. Ananda, learned counsel for the respondent. This is a list the matter before appropriate bench. Preferably within a week from today.
Your lordship. Some specification, your lordship. Again, it will restrict to some other bench.
Pardon?
Some specification to the bench, your lordship.
No, you will definitely know for which bench it has to be listed.
A reference may be made, your lordship, the order of passed by if that
as the order was passed by Mr. Justice P.J. Soikia, Resident list the matter before the secret.
There, as part of the recall is this, they filed a revision petition lordship and I filed a vacation petition lordship. There is an interim order lordship. And in my IA lordship, there is the order lordship directed him to pay 50% of the area amount lordship. First of all, my calculation, the area amount is about 3 lakhs lordship.
About?
3 lakhs lordship. 50% is 3 lakhs lordship. And he disputed lordship that saying that this amount is not correct. As per him, lordship, it may be 86,000 only. So, lordship, I am saying, lordship, this amount is calculated wrong, lordship. And his basis is, lordship, on recording on order lordship with the trial court lordship. Well, lordship, I filed a petition on haphazard manner lordship in that on the basis of that order lordship, my petition, that order was passed lordship. That is reflected lordship. And at that time, lordship, actually I become confused on lordship because his manner of paying the amount lordship is so doubtful lordship. He lordship, after 2-3 days lordship, he paid on one installment lordship. Again, sometime he missed another one installment, again paid another installment lordship. In this lordship, I became confused on lordship. And there is also several orders lordship. About 2-3 times lordship, 50% order was there lordship. The session court also passed order to pay the 50%.
So this IA is preferred for what purpose?
My I was prepared to vacate the lordship, modify the interim order lordship, whereas it is the Honorable Court directed to pay the 50% of the awarded amount lordship before the trial court of the trial court lordship. Trial court amount was 8,000 lordship, and as per this order lordship, he has to pay the 4,000. And in this 4,000 also, he is not paying regular lordship. This 4,000 also.
My lord, I am paying 4,000 my lord till date, my lord,
No,
regularly.
that is not regular
My lord,
lordship.
He claimed, my lord, 3 lakhs and something, my lord, as
Area.
50% area amount, my lord. For my lord, I have submitted a reason, my lord, and this pays 59, my lord. By this order, my lord, area amount, my lord, as on 22nd February 2021, there is area amount of my lord 2,24,000. But
No,
this is, my lord,
this page number 59 is an order.
Yes, ma'am.
Passed by the subdivision,
Yes, ma'am.
subdivisional judicial magistrate.
My lord, trial magistrate.
Golpara, where it is stated that area amount is 2,24,000.
Yes.
Yes,
Yes.
sir?
Out of which, my lord, I have paid already, my lord, I have stated in my lord, paragraph 4, my lord, details statement I have to make, my lord. But as per my calculation, my lord, only 86,000, my lord, and 86,250 rupees will be 50% amount, my lord.
Where you have mentioned it?
My lord, and in page 56, my lord, plus C, my lord. Page 56 plus C. Dependent also pay total amount of rupees 75,500 in terms of interim order dated so and so forth filed. Thereafter, therefore, the deponent has already paid total amount of rupees so and so 1,11,500, and thus after deduction from area amount of rupees 2,84,000 minus so and so 172,500, and from the above calculation 50% of area amount would be 86,250, which is entitled by the applicant in terms of the High Court's order. But due to financial difficulties, the deponent is not in a position to pay the aforesaid 50% area amount of at a time, as he has to pay loan amount, and hence the deponent risk for this honorable court to allow him to pay the area amount on monthly installment basis, considering financial hardship in the interest of law. This is my lord humble submission, my lord. My lord, I will pay, my lord, this 50% amount, remaining 86,000, my lord. But my lord, some time may be given, my lord. This is my complaint.
Lordship, that amount lordship, I am not
My lord,
accepting.
but
Yes, I have filed the reply
but
lordship.
he, my lord, refused, my lord, this part, my lord.
Yes, yes.
It is, my lord, on record, my lord.
It is lordship, how this order was passed, lordship. That's why I have filed this reply. Yes, yes, yes. I have filed this reply, lordship. Lordship, because lordship in the year lordship, so far I have entered on lordship. I entered from the year 2012 lordship. And even if it from 2012 lordship, then it up to 2022 lordship, it ultimately it became about 4 lakhs lordship. But lordship, on that day lordship, how I become confused on lordship?
Okay, you file your reply to this
The reply is I filed.
affidavit.
Yes, lordship, I filed lordship.
You file your reply.
Yes, lordship.
And in the meantime, you pay this area amount according to you.
That must
Yes,
have
sir.
Yes, I will pay, my
86,000.
lord, but some time may be given, my lord. At a time, I am not in a position to pay
No,
this. at a time.
what is your profession?
My lord, I am a teacher.
Your teacher.
Teacher.
Teacher's salary is about 70,000 lordship.
My lord,
Salary?
About 70,000 lordship salary lordship.
I have taken several loans, my lord, which I have stated in paragraph 5.
Lordship, I have also school going side lordship. No, I am also lady lordship, but he lordship in paying in such a manner lordship. Even I cannot lordship manage to food lordship and cloth lordship. This is because lordship every time lordship he missed 2 times. Then he paid only 4,000 lordship. Again sometimes lordship he missed 1 time, but he never paid regularly lordship. Lordship, this is lordship always lordship is increasing the balance lordship.
Pay this area amount within 1 month.
My lord, I have filed another miscellaneous application, my lord. My lord, which is numbered, my lord, 1006, my lord. But I checked, my lord, that is not on record, my lord. So, my lord, another, my lord, order has been found by the Lanet Trial Court, my lord, to pay the area amount without ascertaining, without, my lord, bypassing the High Court order.
You must clear this amount, 86, within 1 month from today.
His challenge is last time trial court also directed that you paid the as per the High Court, sir, you paid this amount.
You file your reply, we'll see. The meantime,
On that,
you complete
in
this,
his evident lordship, he basically I will not find it. Lordship, he said that that cannot be claimed with the trial court. Yes, I also claim lordship. I also paid that the amount can be deposited before the High Court lordship, or lordship it can be directly go to his account lordship. So in his evident miscase lordship, I will not file any reply lordship. His challenge is that the trial court cannot claim this amount. Yes, lordship. That, if not lordship, I will not pay any their lordship. Also, area amount, even lordship, I am given the assurance lordship. If my part is a wrong lordship, that may be lordship that from the trial court lordship or calculation may be collected lordship.
LCR.
Okay.
LCR has been
Heard
also
Mr. Jaswant
also received my lord.
applicant, then Mr. A. Hussain, Lord and Counsel. Pardon? Yes, Lord and Counsel for the opposite party number 1. Mr. Hussain, Lord and Counsel for the opposite party number 1, said he has filed one rejoinder affidavit on 5th of August 2024, and according to him, the amount, the area amount payable to the applicant again is 86,250 rupees. But Mr. Bob Learned Counsel for the applicant has disputed the aforesaid amount and submits that he will file one reply to the aforesaid affidavit. And price for granting supply period is allowed. This submits the matter after 4 weeks.
No, lordship, the date may be fixed. Otherwise, this criminal offence lordship matter.
On 1 month time.
Before vacation lordship or
No, 1 month time. We are granting 1 month time. In the meantime, you will pay the area amount.
My lord, 50% of area amount.
Sorry.
27 January.
27 January. In the meantime, the opposite party number 1 shall clear the area amount of rupees 86,250 before next day. List according.
My lord, another prayer, my lord, I have filed miscellaneous that will be
No, that is not before this court. We will not pass any order.
My lord, in this case, my lord, I have filed.
When?
In this case.
This is not.
That is not, my lord, but case is already come.
ultimately will come.
100.
After 1 month, it ultimately committed.
When the matter will be available before the court, we will consider the same.
Yes,
not now.
What do you want?
Yes.
Last occasion, I was directed to take step upon the respondents.
Yeah.
Few ways, my lord. I have taken steps only in respect of my lord, usual courts as well as the postal talak. on 3/12. But so far the Dosti service is concerned, by mistake it was not taken. But however, my lord, so far the matter is concerned, challenge to the order dated 14/7, my lord. Today is the, my lord, lordship may consider for entering prayer.
Pardon?
Lordship may take note of the last order.
I number?
31. I'm for RTM number 31.
So you have filed IA.
No, my lord, I have not had a. My lord, CRP IU number 485/24.
No, that's all right.
Second day, my lord, it is listed, my lord.
Service report not received. He has not taken step.
So far, my lord, steps is concerned, my lord, I have taken steps as regards to my usual post as well as the postal column. I have submitted on 3/12, my lord. And so far, the Dosti part is concerned, my lord, by mistake it was not taken on that day.
By?
By mistake it was not taken. Inadvertently, it was left to be taken,
You take a step, we will see.
my lord. So far, my lord,
Because of that ground, we have not considered
Yes,
your entry
yes, I-
on the earlier date.
yes, yes. So far,
When
my
the
lord,
other side appear, you take a step.
my lord, that's true, my lord. So far, that part is concerned, my lord, lordship may fix a date so that I can, my lord,
Okay, okay. Heard Mr. M.K. Sharma, learned board of it. Office note dated 12/12/2024 indicates that unserved notice issued to the respondents number 1 to 3 returned with a report postal remark insufficient address. And the said office note also indicates that service report by usual process has not yet been received by the concerned city. Mr. Sharma learned counsel for the petitioner submits that due to inadvertence, step by usual process could not be taken. That price for granting him supply clearing prices are list of better on.
one correction is there, madam. I have taken steps by way of usual process as well as registered. But by mistake, I could not take steps, my lord, by Dosti sir.
But Dusty was permitted.
Yes, yes. Alternative, my lord. May take step.
No, service report in respect of the aforesaid respondents by usual process has not been received by the concerned person. Mr. Sharma learned counsel for the petitioner submits that he could not take step by way of the step of the said respondent. And price for granting supply care is allowed. List the matter on when granted for the intended period the petitioner will be considered on that.
Madam, I love it.
Madam 33.
May I please, Your Lordship? Kindly produce the order dated 39/24. Paragraph number 1, Your Lordship. Heard Mr. So and so, learned counsel for the applicant, who prays for some time for filing an application for condonation of delay in preferring the application for setting aside the abatement of appeal on date of respondent number 5. Today we have filed the application on date of respondent number 5. And paragraph number 3, Your Lordship. This application in Miss Case 3416/2010 has been filed under Order 22, Rule 9 of the Code of Civil Procedure for setting aside the abatement of appeal on death of respondent number 3, namely Mohammad Motiur Rahman. However, the application is not within the period of limitation, and therefore the learned counsel for the applicant prays for some time for filing an application for condoning the delay in preferring the said application. Today morning, we have also filed the miscase insurance.
Third is your good name.
M. Bhattacharya.
M.
Bhattacharya.
Learned counsel for the applicant, and Mr. Sharma for respondent number
2 and 7.
2 and 7. The learned counsel for the applicant submits that purpose to order of this court dated 30th/9/2024. She has already taken steps for filing an application for condemnation of delay in preparing the application for setting aside the abatement of abatement on account of date of respondent number 5 and 3. But the same applications have not been placed on record. Accordingly, it is provided that this is the matter the first week of January after vacation,
Last week of January.
last week of
January.
January. Accordingly, it is provided that this last week of January.
Item 35.
Lordship, in this matter, petitioners was not allowed to sit in the B.Ed examination, my lord. Subsequently, he was allowed to sit in term lordship by honorable court's order, lordship. Now his result has to be declared, your lordship, because the petitioner wants to appear in the TET examination. If the Guwahati University declares his result, because he's to annex the mark sheet, my lord.
Make an adjournment. Who is your second?
PJ Book. He's having bold. That's why voice.
Lordship, student's career is at stake, my lord. No, but result has to be declared, my lord. Result.
I am representing the respondent number 4, that is the principal, and all allegation made against the respondent.
Nothing allegation. Lordship, may kindly have, see my lordship evidence made in the pleadings, my lord. We are not aware of your lordship, why I was not allowed to sit in the examination. I approached this honorable court allowed me to sit in the examination, my lord. Lordship, now my result has to be declared because I want to apply in this TET examination, my lord. For that reason, I need to annex the B.Ed certificate, my lord. Unless the university authorities declare the results.
When the next session will start?
It will already, lordship, we have lordship, already the advertisement has been initiated. Advertisement dated, my lord. Online application will be accepted. My additional affidavit, page 49. Online application will be accepted from 21st of October to 24 to 15 November 2024. Then thereafter, your lordship, the examination will be held, my lord.
We are not aware of their capability. The copy of the capability has not been found.
Lordship, they have today entered appearance from where I'll.
Because that order was passed, last two order was passed, allowing him to sit in the examination without.
Please don't play around the lives of the students.
I am not opposing against the life of the petitioner. Kindly sometime today or tomorrow, he may be allowed to give the relief as sought for, lordship, and the relief which he has already sought for in the petition, lordship, already granted, lordship. Only there is a order for not declaring the result without the leave of the court, lordship. That subsequent development, lordship, they have filed a additional affidavit, but we have not served with the copy, lordship.
Today you have entered appearance from where else?
College
College has engaged you today. He has entered appearance today. I'll some copy your name.
Okay, on Friday you file your.
Lordship.
Friday.
Friday it will be taken up, my speaks title.
Sometime.
No.
Because kindly see, lordship.
No, they are student, no?
Kindly see, I am not allowing him, not against his allowing him to not to sit in the examination. he already granted seat in the both theory and the practical examination. That is only a order, Lordship, not to allow him to declare his
No,
result
no,
without.
you file your affidavit. I'm granting time to you. Next Friday.
More time would be declared.
No.
Because the additional affidavit which they have.
No.
Are not her with us, Lordship, not her to us.
You furnish a copy to
Yes,
him
today
today
itself,
itself.
sir. Yes.
Pardon is big on your Lord Senior Council Assistant and
Before.
big or Lord and Mr.
P. Halder,
P. Halder for respondent number
4, Lord.
respondent number 4 and Mr. A. A. Lord Council appearing on behalf of Mr. P.J. Puka, Lord Standing Council for respondent number 1 and 2. Mr. Halder submits that he may be granted some time to file his counter affidavit. There is allowed rest of the later matter on Friday. Mr. Halder also submits that he has not been furnished with a copy of the additional affidavit furnished by the petitioner.
By today itself, sir.
Ms. Moya, learned senior counsel for the petitioner submits that during the course of the day, she will file a copy of the affidavit. No, she will furnish a copy of the affidavit to Mr. Halder. Place the matter on Friday.
Next.
37.
No, what is the candidate?
Lordship, in preparing the second appeal, there is a delay, 37 days. Therefore, at this stage, notice will go.
But Mr. Bhagavati, learned counsel for the applicant. This application under section 5 of the Limitation Act 1963 is preferred by the applicants for condonation of delay of 37 days in preparing the connected second appeal. Where is the petition and the documents present record? The notice be issued to the respondents returnable in 4 weeks. They be taken by registered counsel in AD and also by the process which can be done today. This is after 4 weeks.
28.
Wait, please, your Lordship. Lordship, this is an MSc appeal, Lordship. We are filed against the Quantum, my Lord, by the insurance company. Lordship, after filing of the appeal, my Lord, both the parties have come to an agreement, my Lord, regarding the Quantum, my Lord. So other party is appearing today, my Lord.
So this IA is for what purpose?
I is for Lordship. It was for the condoning delay, my Lord.
It is we have settled the case.
Yes.
And we lack 50,000. We would have settled it at the last local.
Yes.
But since the case has been already picked over, it is not possible. And so, as we have agreed outside the court, no.
Withdraw this application, withdraw this appeal then.
But before which no, we will have to initially we'll have to settle the case. Then on thereafter, we will withdraw this memo.
Pardon?
Initially, let us file a memo. This one
Settlement.
Settlement and allow it agreement of
When?
Just pursuing.
But first we have to condone this delay.
But
62 days.
yes, but
You have no objection?
I have no any objection.
Okay.
I have no any objection.
Heard, Mr. Polita? Learned
My
counsel
lordship,
for the
I pray
application.
that if
And Mr. Your good name?
I wish you to Goswami. Al Goswami.
Pardon?
Al Goswami.
Okay. Learned counsel for the respondent. This application under section 5 of the Limitation Act 1963 is referred by the read with section 173 of the MD Act is preferred for condonation of delay of 62 days in filing connected MSc appeal against the judgment and award dated 4/7/2024 passed by the learned member MSCT number 2 Kamrup F. Guwahati in MSc case number 2406 of 2006. Mr. Colita, learned counsel for the applicant submits that. Why 62 days delay occurred in filing the appeal?
My Lord, delay is explained at
Paragraph number
Lordship 426, my Lord.
4 to 6. What is the reason?
Obtaining certified copies, my lord, and the obtaining the opinion, legal opinion from the dealing advocate, my lord.
Mr. Colita, learned counsel for the applicant submits that the cause of delay is explained in paragraph number 4 to 6. And that there was delay in obtaining the certified copy and also in obtaining the legal opinion from the council of the appellant. And the same is not intentional, rather it was circumstantial and therefore it is contended to condemn the same. The learned counsel for the respondent submits that he has no objection in the event of condoning the delay of 62 days in filing the MSC appeal, as the matter has already been settled between the parties in local alert held on.
No, we haven't
No,
able to
it-
settle the local alert because it was itself the case is always in this court. Also, if they couldn't able to get the record, so they are unable to settle. But outside the court, we have
It was
already.
otherwise,
settled
lordship,
it.
it was otherwise proposed to be settled before local
As
adult.
the matter has already been settled outside the court between the parties.
At 20 lakh, 50,000.
Pending further submission of learned counsel for the parties, I have carefully gone to the meeting to the record. And I find that the delay of 62 days in filing the connected MSC appeal number that has been sufficiently explained that the same appears to be not deliberate, but is circumstantial, and therefore this court is inclined to conduct the same. In terms of above this IA instance, dispose of. In view of the order passed in the IA, now the registry will proceed to register the MSC appeal and reach the same before this court as soon as practicable.
And this, but this project can be fixed before the vacation, consider that we have to settle the.
You go to the registry. Now registry have to register it and list the for the court. I'm ready to pass any order as soon as it is placed before.
Lordship, may I pray for
In the IA, you have not filed local alert.
No, we have filed only recently, only today, so we got the number. We have filed this one. Okay, okay.
Lordship, may I pray for listing it before vacation if possible, my lord, that instead of as soon as possible, my lord.
No.
Before
We cannot fix that.
vacation.
You go to the registry
My lord,
and ask them if they list the matter tomorrow, we are ready to take.
my lord, my lord, my lord.
Pending item 6, mission.
Also here, I was supposed to file an affidavit. Only yesterday night I received an instruction for in the works of lawsuit. Short time lawsuit. Let me bring it on record. Only
Mr. Sururi, you say Mr. Goswami has already completed his part of argument.
yes, my lord. And he has informed me. Already this court was a coordinate bench also settled. The stipended teacher will get the pensionary benefit as per 67. Another judgment of this honorable court.
So on the basis of instruction you have received, you argue the matter.
No, it's not clear because in respect of that pension part, that clarification I have to take it. Because here it says that he was terminated, again reinstated with prospective effect.
No, there was order of this court to
No,
grant him all the service
there are
benefits.
several similar nature cases are there where they on the basis of the court's order that reappeal they were reinstated and all were given prospective effect, and some have been now accommodated with the since the promulgation of the provincialization act. Because of short time losses, I would like to clarify this point also with regard to the pension part of it. That is not here in the instruction. That's the difficulty. Otherwise, I would have argued it. Okay. Lordship can peruse it. Lordship, the instruction that I received only yesterday night.
So totally, you say the writ appeal was dismissed.
No, but that writ appeal was on the basis of a litigation. It was ultimately closed with regard to the reinstatement of all those terminated
Not only. So what was the order passed by the single bench?
That now I
All the service benefits? What service benefits include?
no, that was not stated in the reappeal order. Only on the basis of the.
No, reappeal was dismissed. Mr. Goswami, before the single judge, was there any prayer for this pension part? Because this order only deals with salary part.
No, no, no. Lordship, petitioner will be paid their
Paragraph
salary. It
number
is made
3.
clear that payment salary, but the petitioner will not be dependent on the interim order passed by this court, meaning thereby. Interim order passed in petitioner shall be paid their salary in the tune of the interim order passed the month.
What is the interim order?
Interim order was to stay the termination order.
Acha. That is at page number?
Interim order I have not annexed because final order has been annexed. Termination was stayed.
So if the termination order is set aside, then you have to grant all the benefits. Not only the salary, but also the other benefits.
Here, Lordship, the teachers were not only the petitioner, others were appointed against non-existent post. And for getting the regular salary, there has to be budget allocation. Since they were appointed in the non-existent post without going through the selection process, that's why they were terminated. Subsequently, they took a policy decision, and on that basis, the writ appeal was withdrawn. But later on, Lordship, the finance department filed a review because the finance was not a party in the writ appeal. Lordship, I will elaborate in all the Lordship might take it up on reopening, just on reopening. Lordship, in the meantime, I will file that.
Okay, then we will keep it as part of the.
Yes.
Part of the so today, so today submits that he has received instruction, then he will file an affidavit in opposition and tries to grant something. There is no matter last week. 6th of January. Recess alleged the matter as part.
Obliges.
16.
May I please, Your Lordship? Here in this case, Lordship, the affidavit opposition has been filed and we have filed the reply with regard to the contention that has been taken. Now, the issue is that, Lordship, the petitioner is paying for a very limited consideration for the post of administrative officer. The required tenure is 2 years for promoting to the post of administrative officer. Now, the petitioner has completed 1 year, 8 months. Only 3 and some months left. So, with regard to the stipulated period of 2 years. So, that has not been considered by the respondent and accordingly rejected the prayer of the petitioner for promoting to the post of administrative officer. Whereas the SCRT, director of the SCRT, if your Lordship kindly see the page number 33, annexure 9.
Who is for the respondents?
Respondent
Mr.
Lordship
Thomas?
is SCRT otherwise supporting the contention of the petitioner Lordship.
SCRT Lordship, they have.
Who is for SCRT?
SCRT Mr. S. Bora. Shantanu.
As for I have seen him.
He was there, Lordship. Otherwise, they have no grievance against the petitioner and they have supported the cause of the petitioner, Lordship. They have forwarded the case of the petitioner before the government.
They can call the board.
Acha, acha. If your lordship, in the meantime, if your lordship kindly see page, annexure 9, page number 33.
Page number?
33, lordship. The director SCRT submitted the proposal to the Secretary of the Department of School Education, the school. In this particular letter, lordship, if your lordship kindly see page number 34, the operative portion. The post of administrative officer in SCRT Assam is quite essential in SCRT Assam. There are 65 teacher education institutions and more than 2,100 number of employees working under the administrative control of SCRT Assam. As such, directorate has a huge administrative tasks related to appointment, promotion, transfer, grant of leave, financial matters, court cases, etc. Considering the long spell, this is important, lordship, considering the long spell of time service rendered by as UDA and superintendent and his experience of doing official works, especially the administrative works, and also the nearest date of superannuation, government may consider the matter of relaxation of service experience of Sri Prabhat Chandra Das for promotion to the post of administrative officer. It is not the case, lordship, that he cannot be considered. There is a provision and there is a procedure. I have also annexed that particular procedure. As per that procedure, lordship, the Assam rules of executive business, there is a provision for considering giving some sort of relaxation of any general service.
Where is that?
It is at page number 37, lordship. Page number 37.
Yes.
This B, personnel B branch. B, concurrence to the proposal for relaxation of any general service rule, relaxation of any general service condition. So here in this case, lordship, the general service condition is from the feeder post promotion to the next higher post is for 2 years. The minimum tenure is for 2 years. Now that can be considered. But the government is not the case that only the petitioner case is there. There are several instances in the affidavit in reply. I specifically made a mention that they have done it. It is the case of the petitioner is that I have made a specific statement. If your lordship kindly see the reply, I'm just taking your lordship to the
Page
reply.
number.
Page number 54 of the reply. The petitioner has highlighted the arbitrariness on the part of the government in not considering the relaxation of the petitioner. Page number 54, lordship, got it?
Yes.
From the middle portion, lordship. 11 from the bottom, it's line number 11, lordship. It is specific case of the petitioner that there being arbitrariness on the part of the respondents in rejecting the representation submitted by the petitioner. Whereas on the other hand, one Joyram Hazarika, who was holding the post of Assistant Director Secondary Education Assam, was promoted to the post of Inspector of Schools Sonitpur by notification dated such and such by obtaining a 6 months relaxation of the service experience from the personnel B department, Government of Assam. And whereas the case of the petitioner has not been forwarded to the state department for relaxation of the service tenure, which makes malaphagy on the part of the respondents to deprive the petitioner for promotion. Now, here in this case, they are taking the plea of not completing the period of 2 years. Now, what has happened, lordship, the petitioner was eligible for promotion to the post of superintendent from the very initial phase, lordship, and he was promoted after 20 years, 28 years, lordship. 28 years, 7 months, 4 days. When the required tenure is only 7 years, he was promoted
8 years,
7 months, 4 days. On 26/12/2019, lordship, he was promoted to the post of superintendent. And that was after a gap of 28 years, 7 months, 4 days from the feeder post of UDA. Now for the next promotional post of registrar, I specifically mentioned in my affidavit.
When the vacancy arose?
Lordship, the Janardhan Das, the concerned person, in the writ petition, I made a specific statement. The vacancy arose, if your lordship kindly see, I have annexed the concerned document with regard to that, lordship. In our representation also, it has been specifically mentioned. If your lordship kindly see, it will clarify the thing. Yes, page number 28.
Yes.
Page number 28, lordship, in the representation.
No, you answer my specific question.
Yes, lordship.
When the vacancy arose?
Lordship, that is what I'm just referring to. Page number, if your lordship kindly see page number 28. Page number 28 is the representation made by the petitioner. In this particular representation, he has made a specific statement in page number 29.
Yes.
29 in the first paragraph, it has been mentioned after rendering a period of 3 years, I have been regularly promoted to the post of registrar. By government notification number dated 30/3/2023. I have joined the post of registrar accordingly on 31/3/2023. As per Rule 61 of the Assam Directory Administrative Service Rule, recruitment to the post of administrative officer shall be made by the promotion from the select list approved by the commission. Now, here in this case, if your lordship kindly see the next annexure, the page number 30. Page number 30. Page number 30, the query that has been made by the Honorable Court with regard to the vacancy arises. It is there in the page number 31. Page number 31. And this concerned person who has retired from service, the petitioner is required to be considered with regard to that particular post. If your lordship kindly see, in 1/1/2024, this is the annexure number 7. If your lordship kindly say 1/1/2024, annexure 7, a proposal has been sent.
Page number?
Page number 30. I'm just referred to. Page number 30 in the fourth paragraph. At present, there are no superintendent working in the third paragraph. At present, there are no superintendent working in the Directorate of SCRT. They have clarified that thing, lordship. Guwahati, a proposal for filling up
That's
of
all
that.
right, but when the vacancy arose?
Since 1/8/2020, lordship, the first paragraph with regard to that particular proposal, because for last 2-3 years there is no person holding that post of administrative officer. It has been specifically mentioned that with reference to the subject cited, I have the honor to state that the post of administrative officer in the Director of SCRT Assam Guwahati has been lying vacant since 2020. So for last 3-4 years, there is no person holding the post, and that is the reason why the Director
What
of
is the
SCRT
qualification for qualifying service for
register
promoted to
register for 2 years.
administrative officer?
Register for 2 years. The feeder post is the register. And I'm just 3 months, some days, I have not completed the period of 2 years. 12 days. So this is the reason why they are not considering my case. Whereas the specific provision that it can be considered and they can send it to the
Register for 2 years.
register for 2 years. As per the provision of lordship, this Assam Education, Research and Training, Gazetted and Non-Gazetted Service Order 2017. I will give a copy of that, lordship. With regard to
Not
that,
part of the
this is not a part of the writ petition, although they have mentioned it. They have made a specific mention in the communication. Even in the affidavit in opposition also, they have made a mention with regard to that, lordship.
Then and how many months left?
3 months, lordship. Only 3 months, 12 days. I'm going to retire in the 31st of December 2024. December 2024, lordship. This year, lordship.
So where is your representation for?
Yes, lordship. Representation, it is there at page number 28, lordship.
Qualifying period?
Page number 28, lordship, annexure 6.
And what action was taken upon this representation?
Yes, lordship. This is the last annexure, not last. Is the annexure number 35, lordship. Page annexure number 10, page number 35. They have regretted my this representation. If your lordship kindly see annexure 10, page 35. The concerned authority of the Department of School Education, in inviting a reference to the letter of the subject cited above, I am directed to convey regarding a proposal for filling of the post of administrative officer of SCRT Assam by way of promotion from the feeder post of registrar. That is the lonely incumbent. I am the lonely incumbent, Lordship, and they have admitted that. Sri Prabhat Chandra Das, registrar of SCRT Assam, has not entitled due to non-fulfillment of required tenure. Then he may be regretted for the said promotion. Now the required tenure is only 2 years, and I am just falling short of 3 months, some days, Lordship, 12 days. And in the specific affidavit reply, we made a specific statement with regard to the fact that it is.
The question is, can this court under.
No, since the
Article
provision is there, Lordship,
226
that's why I refer to this personal B branch, if your Lordship kindly see page number 36, 37, the Assam Rules of Executive Business 2023. There is a specific provision with regard to that, Lordship. The personal B branch concurrence to the proposal for relaxation of a general service rules and a general service conditions. Since the relaxation provision is there, Lordship, they can act upon on that. And it is their communication, Lordship. If your Lordship kindly see, it is their communication. They have made a communication, if your Lordship kindly see page number 32, annexure 8. It is from the concerned authority of the school education.
Mr. Bora, you are for SCRT?
Mine only limited, man. This is the section that is by the government.
Decision was taken by the government.
Government. That is the mine only limited. Because
They are otherwise
others were favoring the person.
favoring the petition.
Favoring the person by writing letters and to accommodate. But the government has come in.
The thing is that it is a discretionary power of the government. Can this court issue mandamus to relax the?
No, Lordship, when there is a procedure is there, the procedural part is also there, Lordship, when the legal obligation is there, and they have done it. So in the affidavit in reply, we have made a specific statement with regard to the fact that in one case they have considered to send it to the personal B branch for relaxation. On the other hand, they are just depriving the petition, and there too,
Yes, Mr. Sharma.
it is their fault after 28 years,
Person is
Lordship.
retiring very soon.
Yeah.
Only few days are left.
Lordship,
Our affidavit.
Page number?
Page number 47.
He
is not qualified.
Not qualified. 2 years. Paragraph number 7 law. 6, sorry. And Assam that as per the education, Assam Education Research and Training Agency Service Order 2017, the post of administrative officer SCRT Assam is to be filled up by way of promotion from the post of registrar. SCRT Assam having 2 years of regular service as registrar. Admittedly, the petitioner has completed only 1 year, 5 months, and 18 days, as on 19/9/2024 as registrar, and hence he is not eligible to be promoted to the post of administrative officer. Be it be stated herein that since the case of the petitioner was not considered for relaxation of service to give him the promotional benefit, therefore no referral has been made to the personal B department for approval. Paragraph number 7 is also here also, that the answering department humbly explicit that it is in the exclusive domain of the administrative department to take a decision on relaxation of service condition in order to give benefit of promotion to its employees. The administrative department shall consider the requirement of service of the employee for public interest in order to give the benefit of out-of-turn promotion by relaxing the service condition. In the instant case, the administrative department has decided that there is no public interest involved to grant out-of-turn promotion to the petitioner by relaxing the service condition, and hence the matter has not been referred to the person with department for its approval.
So, Mr. Chaudhary, do you have any authority in this regard?
I will place that, Lordship. This equality of opportunity, Article 16, is very much clear, Lordship. When I have specifically made a mention in our reply, in one case they have considered promotion or they have considered for giving relaxation to a particular person, there is no reason for declining with regard to the petitioner. And whereas, Lordship, for last 28 years, after 28 years, the petitioner was considered for promotion to the post of superintendent. And there is apparent casual approach on the part of the respondent authorities in not considering the petitioner at the right point of time to be promoted in the particular post, Lordship.
No,
Had even-
whether there was any vacancy at that time.
Lordship, there were vacancies. I specifically made a mention in our repetition, Lordship. There were vacancies at the time of register also, there were vacancies, but they considered it after 10 months. So each and every time when there were vacancies, petitioner had repeatedly approached the authorities, but that was never been considered. In the writ petition also, Lordship made a specific statement. If your Lordship kindly see one annexure. Here in this case, the person was considered to be promoted to the post of registrar, but he was considered for registrar after a gap of 10 months. If your Lordship kindly see my representation in page number 28. In page number 28, he made a mention that he was eligible and there are vacancies to be considered for his promotion to the post of registrar. If your Lordship kindly see the page number 28.
So when that vacancy arose,
Yes, Lordship. Accordingly, I should have been promoted to the post of registrar in the year 2022. But after rendering a period of 3 years, I have regularly been promoted to the post of registrar by government. I have joined the post of registrar accordingly on 31/3/2023. And that aspect of the matter we have specifically mentioned in our the writ petition, contention of the writ petition. If your Lordship kindly see, I have made a specific statement with regard to that. If your Lordship kindly see this, the page number, paragraph number 6, annexure 6, page number 6, paragraph 6. I'm just starting from the superintendent Lordship that the petitioner states that being aggrieved thereby he had submitted on representation on 24/1/2019 to the respondent number 4, thereby highlighting the injustice meted out to him and accordingly paid for promoting him to the post of superintendent since during the relevant period of time he was the next senior most UDA to the establishment to be considered for promotion to the next higher post of superintendent by graduation list since the said post would be fallen vacant on 31/1/2019 on the superannuation of one Sri Janardhan Das. But no action was taken by the respondent authorities which speaks of the high-handed approach, thereby depriving the petitioner from his legitimate claim. It is pertinent to mention in the along with the representation dated 24/1/2019, the petitioner attached an order dated 2/5/2024, which goes to show the date of retirement of Janardhan Das on 31/1/2019. And the said Janardhan Das at the time of superannuation was holding the post of superintendent, which is very much evident from the pay bill dated such and such. In that view of the matter, the petitioner being the senior most upper division assistant was eligible for promotion pursuant to superannuation of the then superintendent on 31/1/2019. But the respondent authorities, without any just and cogent reason, delayed the promotion of the petitioner. Subsequently, after almost a year, the petitioner was promoted to the post of superintendent by notification dated 26/12/2019. So in each and every case, Lordship, each and every time when this after falling vacant with regard to a particular post, he was not immediately considered. Every time he had to submit the representation, therefore he was considered. And by that period of time, there was a gap of 10 months, 12 months, something like that. And that is the reason why, Lordship.
Mr. Sharma, is there any notification of the government regarding constitution of DPC and about sitting? Pardon?
I have to find out.
So after how many years the DPC sit?
Petitioner is going to retire in this month, Lordship, 31st. So again, only 2-3 days left. Since this specific provision is there, and we have specifically made a mention in a reply also, they have considered the case of a certain person for sending it to the concerned department for relaxation. In this case also, they can do it, Lordship. They are not going to be prejudiced in any way. If your Lordship kindly see, I'm just referring to one more paragraph,
Is
Lordship.
there any DPC in the, Mr. Bora, is there any DPC in the department? SCRD. But why the DPC has not considered his promotion in time? Because in some other states there is notification that DPC should sit in every 6 months or like that. Is there any notification in the SCRT? You appraise this code at 2 p.m.
Yes, Lordship.
today.
Timing 19.
May I please, your lordship? Whether your lordship will sit.
How much time you will take?
That depends, my lord.
10 minutes,
10 to 15 minutes, my lord.
10 to 20 minutes.
10 to 15 minutes, my lord.
10 to
My lord, your lordship desired to know only about whether there can be a conditional gift on that very date. On the
whether
last
there is?
Your lordship was desiring to know, can there be a conditional gift?
Yes.
Conditional gift.
Yes.
So on that, on that day, my reply was in affirmative. Today, I have in support the decisions also that there can be a conditional gift. So if the conditions are not fulfilled, my lord, then in that case, I have a good case. If the conditions are not fulfilled, because the conditions do not make any absolute restraint on alienation. So it is not hit by section 10. My learned friend on that day was arguing that the appeal is hit by section 10. But it is not, because the conditional is not a condition precedent. Rather, it was a condition only that in case of sale of the property to anybody, let it be sold to the heirs of Brajendranath Sir. Brajendranath Deka. That was the condition. So in case of sale, why it was, my lord? Because the property should be intact and it should be within the family. A stranger should not come.
No, whether that condition can be imposed.
There is a judgment. There are judgment, my lord. There are judgments, my lord. So let the appeal be admitted. Let the substance.
Let it come on second now. Let us see whether that only wanted to know whether there can be conditional. Definitely, my lord wanted to know that whether there can be conditional gift with the condition as imposed in that. Otherwise, conditional gift, there can be conditional gift. That is what it is. But conditional gift, it has to be legal. Legal condition. Condition has to be lawful condition. So whether that condition is lawful under section 10, that is. So both the courts below had held that no, the condition imposed is not lawful condition. That is in contravention of section 10 of the Transfer of Property Act.
That's required
And that
interpretation.
Supreme Court also held that yes, you cannot have a condition in contravention of section 10 of Transfer of Property Act. To bar the sale, bar alienation of property, absolutely they cannot do it. Now, only thing is that whether a condition that if you want to sell it, you can sell it only to Bhajananath Hazarika or to his son and daughter. Not legal heirs, or only his son and daughter.
Definitely.
Whether that is absolute restraint or
partial restraint.
partial.
That is required to be
That
interpreted.
is only needs to be seen. So only that entire case is based on that. So lordship can see whether the trial court and appellate court has come to handing rightly. If it is correct, then there is no substantial question of law involving the appeal. Unnecessary keeping it after admitting, keeping it pending. If there is no merit in the appeal, it is not required to keep it pending. Just it should be nipped at the bud. It should be nipped at the bud. It's not, because already my client is suffering. That is why lordship is hearing it. That is your lordship. Otherwise, so if lordship can hear it, it can be second time. It cannot be 10 or 15 minutes, it will take some time.
Okay, at 2 p.m. then.
Okay.
Immediately after dealing with one red petition, there
My lord.
some information is everything. Immediately thereafter, we will hear this.
Oblige, your lordship.
It depends on the vacancy. The thing is that when there is one gazette, direct or CRT will take the call, which will be hit. So if the gazetted, it goes to the com. This particular post is a gazetted post, so it is sent to the com.
So here vacancy arose long back. Why his was not considered?
That needs a road. The record had to be seen. Why this had not been considered and all.
Pardon?
Why record had to be gone through. Why what has happened in between? Only thing is that this is a telephonic instruction, my lord.
Is there any record in your office?
Definitely there will be some record how things have gone.
In your
The
office?
long back, lordship, whether they will be in a position to trace out all these records.
Pardon?
Whether they will be in a position to trace out all these records. A long back, this thing has happened. The
exactly what happened
in each and every date, my lord, we had to be seen, my lord. Why it does not stand on everything? Thing is that he is having no time. That's the reason. Only 4 days and left. In 31st, he will repair.
So, let it be produced before this court on
Oh, well,
Wednesday.
only thing is the government has fact is clear, my lord, that particular period which is required to require, that is not there. And government has rejected only because that particular period he has not completed. And government has only taken a call. That's why he did.
No, that's all right. And now I am not on that point. I am on the point that why DPC could not be held in time. Had it been in time, he would have get promotion. Then he would have acquired the required qualifying service period. It is true that his right to promotion is not a fundamental right, but right to be considered. That is fundamental right. Produce on Wednesday. We pass the order on that day.
On Thursday. Or on Thursday, Lordship. They will get 2 days time to find out all these things.
Thursday.
Thursday.
Okay. Heard Mr. S.P. Chaudhary, Learned Counsel for the petition. And also heard Mr. Bora, Learned Counsel for the respondent number. Mr. Bora, you are for respondent number? 4.
Yeah.
And Mr. Sharma for respondent number 123. 1 and 3. 1. 1 and 3. 1 and 3. List the matter on Thursday.
Thursday, Lordship.
So as to enable Mr. Bora to produce the record of Mr. concerned file regarding promotion to the post of. What was the post?
Superintendent subsequently registered, Lordship.
Superintendent.
And register.
Superintendent and register of SCRT.
SCRT.
SCRT. List the matter as part of.
Item 19, trying to get.
So, my lord, it is an admitted position that conditional gifts are valid.
Conditional gifts are valid.
Are valid.
But
Or
whether
one
the
can make a
condition
gift.
imposed therein is it is valid or not, that has to be seen.
Yes, exactly, my lord. Exactly. That's what I was. Conditions can be made in a gift. That's why it is known as conditional gift. So once there is a condition, my lord, the honorable court is to see whether the conditions are valid or not and whether they create any absolute restraint on the right of. That is. For that purpose only, my lord, so far the admission is concerned, it is required. Because your lordship should see in detail what are the conditions and whether those conditions are creating any absolute restraint on the power or right of alienation. Alienation, yes.
Whether admission is necessary.
For that purpose, my lord, admission is necessary.
No, at the time of
Admit
admission
the
also,
appeal,
we
my
can
lord.
consider the matter. We have to see whether there is substantial question of law. Or
Yes, yes, yes.
not.
Definitely,
If
my lord,
there
your
is no
lordship is to see.
substantial question of law, then there is no question for admitting the matter.
So, my lord, may I take your lordship
Yes.
regarding the perversity, because perversity is one which entitled me to get my appeal admitted for the purpose of adjudication. So, if I can take your lordship to, if I can take your lordship to page number, my lord, of the judgment. The judgment starts from 177 to, my lord, 179. And particularly, my lord, page number 170 is that paragraph. My lord, may I read that paragraph number 54? Now, arriving again to the instant dispute in hand, it is seen that condition imposed upon Gunoda Bala Das And that condition does not specifically says that it will also be applicable to the inheritors of the property after death of said Gunodabala Das. The condition is not appears to be specific about its applicable to the inheritors of the property donated to Gunodabala Das, and as such, the said condition is stipulated for the donee may not be enforceable on the inheritors, defendant number 1, for several reasons. Now, my lord, the reasons are also shown. Firstly, since the inheritor was unaware of the condition and it was not explicitly included in the gift deed and applicable to them, accordingly, the court may interpret that the condition was intended solely for the purpose of donee and did not extend to the heirs, inheritors. Then 2, the inheritor acted in good faith in selling the property described in Schedule D of the plan in favor of the defendant number 2 without being aware of the condition. This is a remarkable line which the learned appellate court, my lord, has told that the inheritor was not knowing about this condition, unaware of that condition. Unaware of that condition. Consequently, third, my lord, consequently, the sale to a third party by the inheritor would stand and the condition would not bind the new owner. My lord, from this paragraph, I would like to take your lordship to page number 54, my lord, and 49. Because the learned first appellate court hold or has held that they were not aware about the condition. My lord,
54.
49 and 56, my lord, because that is the typed copy.
49 and 56.
Yes, my lord. 49, first I am taking your lordship to fourth line. Fourth line, page number 49, my lord. Fourth line. My husband was died on 18th June 2006 and his mother, Srimati Gunodabala Das, expired on 23/1/2008. I have gone through Exhibit 5, gift deed. That is the gift deed, my lord. She has gone through, she is saying. I am aware of the conditions of the said gift deed, number 6483/78, dated 11/8/1978. My lord, on the one hand, the first appellate court is opining that inheritors were unaware about the conditions. The person who has deposed before the learned trial court, as well as before they say that I am aware about the condition. I am aware about the condition. I am aware of the conditions of the said gift deed number dated so and so, Exhibit 5, my lord. I have mentioned about the condition of gift deed in para number 4 of my evidence in chief. It is the further aggravating the same by saying that I have also mentioned about that condition in chief, my lord, in paragraph number 4. During the lifetime of my husband, his mother had not transferred any property to him. I mean, to her husband, the mother had not transferred any property. In paragraph number 4 in my evidence in chief, I have mentioned that if Gunodabala Das, apart from transferring the property to Biswajit Das, could have transferred to any other person, then it should have been to either Brajendra Nath Hajarika, so late son of late Purna Kanta Hajarika, or his son and daughters, and his son and daughter. And that was the condition, my lord, in fact, that if at all you are going to transfer this property, you have to transfer, or you shall transfer, or you must transfer to the progenies of Brajendra Nath Hajarika. Brajendra Nath Hajarika. These conditions, as mentioned in Exhibit 5, is a condition 1. The present plaintiff is the son of the sister of Gunodabala Das, wife of Brajendra Hajarika. Brajendra Nath Hajarika is the same person as mentioned in para number 4 of my evidence. Brajendra Nath Hajarika is the father of the plaintiff. After the expiry of Gunodabala Das, I had claimed as the heir of Gunodabala Das and got my mutated I respect of the Schedule 1, in respect of schedule land. It is not a fact that I am not the heir of Gunoda Bala Das. Though in my evidence in chief, I have stated about the disturbance caused by the plaintiff and family members, but I have not filed any FIR. So, my lord, so far as this statement is concerned, and furthermore, my lord, one line, in paragraph number 6 of my evidence in chief, I have mentioned about condition number 4 of the gift deed, which speaks about common approach of road of 9 feet, and the same 9 feet wide passage is mentioned in Schedule E of the plan. Before selling of the land to defendant number 2, I was abiding by the condition number 4 of the gift deed. So out of the 4 conditions, my lord, one condition, the defendant number 1 is saying that I had abided by that. But so far the other conditions are concerned, she has not abided by, and rather she has alienated the property to an stranger, my lord, who is not from the family of Brajendra Nath Hajarika, not from the family. So, my lord, what is the perversity? My lord, if there is an evidence, may I read that 4 lines, my lord? If the finding of the court are based on no evidence, then it is perverse, my lord. Evidence which is thoroughly unreliable, then also it is perverse, my lord. Evidence that suffers from the vice of procedural irregularity, then also it is perverse finding, my lord. And the last, my lord, the findings are such that no reasonable person would have arrived at those findings. Whereas, my lord, the learned First Appellate Court has come to the finding that so far the inheritors are concerned, they were not aware about the condition. On the contrary, my lord, the very person who is the inheritor of the family, she says that I am aware about the condition and I have abided by one condition, my lord, out of the 4 conditions. Then why not the 3rd and 4th one, my lord? At least, my lord, as per section 22 of the Hindu Succession Act, she ought to have offered first to me. If I would have refused to purchase that property, then the question would have been different. Now, my lord, to be specific, if I can take your lordship to the conditions which were mentioned in the gift deed, Exhibit 5, my lord, then the matter will be, I think, perhaps, according to me, my lord, it will be more appreciable. It is at 2 places, my lord, page number 30 also, that speaks about.
30.
Yes, my lord, regarding the conditions, my lord, it starts from page number 30, last para, 1, then 2, 3, and 4, my lord, 4 conditions. May I read, my lord? That until we die, I mean the donor, until we die, that is the donors, the donated property shall be owned and possessed by us for our dwelling purposes, and during that period, the donee, that is Srimati Gunoda Bala Das, shall be responsible to maintain us. My lord, this is a condition which is not creating any type of absolute restraint on the enjoyment of the property. Because looking to the age, my lord, my lord, that the husband of Srimati Gunoda Bala Das, that is Shri Birendra Singh, son of Shri Arjun Singh, shall have no right of any kind over the donated land. However, the son of Srimati Gunoda Bala Das shall have the right of use and possession of the donated land. So, my lord, so long he was alive, he enjoyed the property. Vishwajit Das. Vishwajit Das is the son of Gunoda Bala Das. Yes. Now, condition number 3, my lord, that in case of arising of any eventuality for alienation of the gifted land to any other person other than her own son, then the donee, that is Srimati Gunoda Bala Das, shall have to alienate the same either to Shri Brajendra Nath Hajarika, son of late Purnakanta Hajarika, or his legal heirs, sons and daughters only, and not to others. This is condition number 3, my lord. Here also, there is no absolute restraint as contemplated under section 10 of the Transfer of Property Act. It is a conditional restraint, my lord, that if you desire to alienate the property, alienate it, but you are to alienate to the progenies of Brajendra Nath Hajarika. And condition number 4, my lord, which she says that I have abide by, that at the northern side of the donated land, there shall be a passage measuring 9 feet in width, arising from Shantipur main road and culminating into the land of Shri Brajendra Nath Hajarika, because my house is just by the side of that. For the ingress and outgress of all concerned, and the said passage shall be kept free up to 60 feet height, and it cannot be made the subject matter of any construction either for dwelling purposes or for storing of any materials, or shall be encumbered in any manner whatsoever. This is, my lord, these are
But
the.
this condition number 3.
Yes, condition number 3. May I read again, my lord?
Yes.
That in case of arising of any eventuality for alienation of the gifted land to any other person, either than her own son, then the doni, that is Srimati Gunodabala Das, shall have to alienate the same either to Shri Brajendra Nath Hajarika, son of late so-and-so, or his heirs, sons and daughters only, and not to others. And not to others. So,
Is
my
it
lord,
not absolute correct?
so here it is in that way, my lord, it is not the absolute restraint on alienation. Alienation is permitted. A condition is imposed, my lord, that
But
in
to
case.
a particular person.
Yes, particular person. So I am entitled for offer, my lord, that if I am not in a position to purchase, or my heirs are not in a position to purchase, then the question would have been different, my lord. This is the first case before your lordship or before the Honorable Guwahati High Court where the conditional gifts are required to be interpreted. Yes, my lord. So, my lord, Section 10 contemplates that there should, if there is any absolute restraint, then in that case, that restrainment is bad in the eye of law. It is void. But if it is a conditional restraint, then that condition is bound to be obeyed by, and that was upheld by the Honorable Supreme Court in Zoroastrian's properties case, my lord. I am giving my lord to do.
Which paragraph?
My lord, Zoroastrian paragraph number 44 is more important.
44.
Yes, my lord, it starts from 42 and said 44, my lord. 44 is more relevant, my lord. 41, 42, and 43, 44, my lord. That is the, I mean, the view stated by the Honorable Supreme Court in view of. In view of what we have stated above, we allow this appeal, set aside the judgment of the High Court and the orders of the authorities under the Act, and uphold the right of the society to insist that the property has to be dealt by respondent number 2 only in terms of the bylaws of the society and assigned either wholly or in part only to persons qualified to be members of the so-and-so. The direction given by the authority to the appellant to admit respondent number 3 as a member is set aside. Respondent number 3 is restrained from entering the property or putting up any construction thereon on the basis of the transfer by respondent number 2 in disregard of the bylaws of the society and without the prior consent of the so-and-so. My lord, kindly come to, my lord, this paragraph number 41.
Sir,
Then it will
sir.
be, yes, my lord.
Yes, in this case, there is bylaws of the society.
Yes.
So bylaws restrain him from alienating the property.
Yes.
But in this case, the present case,
It is
there
the,
is no such law.
yes, no such law, but it
there
is
is
the,
only condition in the gift deed.
true, my lord. It is the wish and desire of the property holder, my lord. I am the owner of the property, my lord. It is my wish that so long I am alive, the person to whom I have gifted the property, he is to look after me. My lord, that condition is absolutely valid in the Indian context because old people cannot
that's
look
all
after.
right.
Now, my lord,
We are not concerned
after
with that.
that, my lord, after that, if there any eventuality arises to sell, otherwise, what I contemplate that there shall not be any eventuality to alienate the property because the property is mine. With this wish, I am alienating or rather gifting it to my heirs that they should keep it intact. That's why the word, my lord, eventuality is used, that in case of any eventuality, if at all the property is desired to be.
So, Mr. Chattra, is it your case that they have not offered it to you
Yes,
first
correct.
and thereafter to the other side?
Exactly, my lord. Exactly, my lord. Exactly, my lord. Your lordship has come to that conclusion, which rather I was wanted to argue at the last. Yes, my lord. That is. They should have offered because my property is property of the family. It should have been, a stranger should not have been brought, my lord. That is my. They cannot show that they have ever offered that property to me and I have denied to purchase. I have denied to purchase. And it is also, my lord, there in the cross-examination.
Yeah, that's all right. But the question is, uh, after the death of Gunawala Das,
Yes, my
what
lord.
the trial court has held that, the first appellate court had held that after the death of Gunawala Das, the property, no, the conditions are not binding upon the inheritors. of the
Inheritors,
property.
yes. Let me just elucidate
Explain,
that
yes.
that part. My lord, the condition is attached not only upon the person but with the land also, my lord. That in case of any eventuality to sell out the property, then it should be sold out to so and so, so and so. So this condition precedent, my lord, is not only attached to the person but attached to the property also. That's why my husband was rather debarred from and said that Biswajit Das can only enjoy the property during his lifetime, though he is the son of Gunodawala Das. In condition number 3, my lord, that is mentioned. So, as your lordship has asked, there was no any offer to me before the alienation of the property to defendant number 2 by the defendant number 1.
What about the other decision?
Other decision, my lord, that
Kanailal.
Yes, sir. This para 16 and 17, my lord. Para number 16 and 17, my
No,
lord.
the other judgment is that is Kanailal.
My lord, 2019, yes. No, my lord, S.
1999.
Amma versus.
No, this is a.
My lord,
Yes, you have
2019,
given it.
11 SCC.
It is not your judgment.
My lord, that is also my judgment, my lord. The second is, my lord, 2019. That may be wrongly given to your lordship, my lord.
Maybe earlier, earlier.
Okay.
That was given on the last date. Yes.
No, today you have given it along with this judgment.
My lord,
Zoroastrian.
Zoroastrian we have given, my lord. And this is 2019 11 SCC, my lord.
Give a copy to me.
Yes, ma'am. Huh? Yes, I agree. 2019 11. May I read para 16, my lord? Para 16. We are in agreement with the decision of this court in Renu Kuntala Rajamma.
Paragraph number?
16, my lord, 16, at page number 394.
Yes.
We are in agreement with the decision of this court in Renu Kuntala Rajamma that there is no provision in law that ownership in property cannot be gifted without transfer of possession of such property. However, the conditions precedent of a gift as defined in section 122 of the Transfer of Property Act must be satisfied. a gift is transfer of property without consideration. Moreover, a conditional gift only becomes complete on compliance of the conditions in the deed. Now, my lord, para number 70. In the instant case, admittedly, the deed of transfer was executed for consideration and was in any case conditional, subject to the condition that the donee would look after the petitioner and her husband, and subject to the condition that the gift would take effect after the death of the donor. We are thus constrained to hold that there was no completed gift of the property in question by the appellant to the respondent, and the appellant was within her right in cancelling the deed. The judgment and order of the High Court cannot therefore be sustained. So, my lord, the last line of paragraph number 16, that a conditional gift only becomes complete on compliance of the conditions in the deed. This is what the observation of the Honorable Supreme Court, and this is what also I place before your lordship for consideration.
It's all right, but here expressly the court has not dealt with the issue.
That's why it is required to be determined by the Honorable Court, this Honorable Court.
But some all judgments are there.
My lord, we have the bunch of the judgments, but we don't want to take your lordship to those because it is very bulky. We have already prepared a list of it, my lord. List of it. We will submit it at the time of hearing, my lord.
Mr. Torma?
My lord. Here, the trial court has decided 2 points. But trial court has decided 2 points. Firstly, whether if there is anything in the gift deed that it will be binding upon legal heirs of Gunada Balada. Condition number 3.
Such condition was not there.
No, there is nothing. My lord may only see the gift deed. It is nowhere. Only for Gunada Balada. Gunada Balada shall not transfer. It is not that Gunada Baladas or her legal heirs are not transferred. That is what High Court has dealt with the matter. Lordship, they have referred it, page 170.
Page number?
170 they have referred.
170. Yes.
Now arriving again to the instant dispute in hand, it is in that condition imposed about Gundada, and that condition does not specifically say that it will also be applicable to inheritance of property after death of Gundada. The condition is not appears to be specific about its application to the inheritance of property donated or to Gunada. And as such, the state condition stipulates for the donee may not be enforceable on the legal heir for several reasons. Firstly, since the inheritor was unaware of the condition and it was not explicitly included in the gift deed as applicable to them, according the court may interpret that the condition was intended solely for the donee and did not extend to the inheritor. The inheritor acted in good faith in selling the property established obtained in favor of defendant without being aware of the condition. Consequently, sale to the third party by the inheritor would extend and the condition would not be bind the new owner. Then court says that the legal precedent such as Ramesh Chandra versus State of Haryana 2019 and Kamala Devi versus Srimati Kanta Devi have established that conditions in the gift deed do not automatically apply to the heirs or successors of the donee unless explicitly accepted. So, there may be conditional gift, but conditional gift deed has to be interpreted strictly as mentioned there. At there, it is written that this is the Gunada Baladas or her legal heirs cannot transfer the property to any other person except such and such and such. That is one thing. It is not mentioned in the gift deed. Gift deed says only about Gunada Baladas. After her, what will happen? Not mentioned. So automatically we cannot say that yes, since it was binding upon Gunada Baladas, so it will again be binding upon the legal heirs. That cannot be said automatically. Secondly, they said that they have argued one point that inheritor acted in good faith by selling the property without being aware of the condition. They have shown some part of the evidence, my lord. But those part of the evidence which they have shown that firstly, Lordship can see that your Lordship is aware of the trial court proceeding. Firstly, gift deed has been shown to her. Yes, I have seen the gift deed. Now you say whether you are aware of this condition, whether this condition is there. Yes, is there. Yes, this is condition. It is not the evidence that I know the condition, that I know the conditions of gift deed at the time of executing the sale deed. It is not there. So if two interpretations are available on record, in case of concurrent finding of fact, this honorable court will definitely not interfere with. There is not, they have shown evidence before the court where it is put in the mouth of the evidence that yes, it is the sale gifted. Yes, it is gifted. See, have you go through the condition? Is it the condition? Yes, it is the condition. I am aware of the condition. It is not mentioned in the in cross-examination that I know the condition when I have executed sale. That is not there. So two views are possible. So one view taken by the trial court cannot be will not be interfered by the court in concurrent finding of fact. That is one. I shall go to the law court.
Yeah, that's all right.
Then the main thing is that. Then the main thing is that, madam. The main issue is before the court that whether it is absolute restraint or whether it is partial restraint. That is the main issue. Nothing else. That is the main issue. If it is absolute restraint, definitely the condition goes and the gift deed will remain valid. Gift deed will remain valid except the restraint. My lord. They have said that, my lord, that I am agreeing to other conditions, but I am not agreeing to condition number 3. My lord. That's section 11 of the transfer of property.
11 of the
Transfer of property.
okay.
Let us start from section 10. Madam. Section 10. Okay.
Yes.
Where property is transferred subject to a condition or limitation absolutely restraining the transferee or any person claiming under him, even claiming under him, parting with or disposing of his interest in the property, the condition or limitation is void. Condition or limitation is void. Not the transfer is not void. Condition or limitation is void. Except in the case of a lease where condition is for benefit of lesser or those claiming under him, provided that property may be transferred to or for the benefit of women, so that he may not have any power during her marriage or to transfer or change the same in her beneficial interest therein. So, it says that if it is transferred with condition, restraining the alienation, condition will be verified. Deed will not be verified. Then 11. Where on a transfer of property and interest therein is created absolutely in favor of any person. So in this case, by transfer, absolute interest is created in my favor. The gift is absolute gift. Gift has been registered, power, rights and titles has been given to me, but the terms of the transfer direct that such interest shall be applied or enjoyed by him in a particular manner. He shall be entitled to receive and dispose of such interest as if there was no such direction. As if there was no such direction. So, I am entitled to receive the gifted property as if there was no such direction. Court says that, the law says that the condition, if condition is illegal, I still receive the gift except those directions. Then there is one exception. Next, where any such direction has been made in respect of one piece of immobile property for the purpose of securing the beneficial enjoyer of another piece of property, nothing in this section shall be deemed to affect any right which the transferor may have to enforce the direction or remedy which he may have in respect of which there. So they say that I have accepted number 4. Number 4 is that there will be a strip of land which will use the path for me as well as for the plaintiff whose land is in back side. So that condition number 4 is covered by this exception. Because his right will be affected, so I have to maintain his right for a piece of land, and I have never interrupted it, and I have admitted that. So the thing is that if there is absolute restraint, the condition will be void. The condition will be void. My lord, in this regard, my lord, they have referred to Georgian Society Act. My lord, that is absolutely not applicable in this case. That was, my lord, a society formed by a minority community, Eurasians. They have formed a society. By forming a society, they have purchased some property of the society, and some persons have obtained membership in the society. And after
No, they have their own bylaws.
yes, they have
They are
their own bylaws.
governed by the said bylaws.
And that will they are protected by Constitution of India for minorities. So that law is not applicable here. That is different, altogether different thing. Now, my lord, they say that the, it is not absolute text. So, my lord, in this regard, my lord, the gift deed may be looked into, my lord. Gift deed, we may look into gift deed, my lord. I have supplied copy of evidence, my lord. One for a bunch, one complete bunch is there. Copies of evidence and exhibits. There, my gift deed is there. Of course, they have also supplied it, but that gift deed may kindly.
Here, page number
Page number 38, my lord.
38.
38 of my bunch of the.
When you have given it to the court. Yes.
My lord, my lord.
Page number?
Page number, my lord. May look at page number 38, my lord.
Yes.
দানৰ চৰ্তসমূহ নম্বৰ 3 লেটেষ্ট চৰ্ত নম্বৰ যদি কোনো কাৰণবশতঃ নিজৰ পুত্ৰৰ বাহিৰে আন কাৰোবাৰ পুত্ৰত উক্ত দান কৰা ঘৰ আৰু মাটি হস্তান্তৰ কৰিব লগা হয় তেন্তে শ্ৰীমতী গুণতা বালা দাসে উক্ত দান কৰা মাটি আৰু ঘৰ কেৱল মাত্ৰ শ্ৰী বজেন্দ্ৰনাথ হাজৰিকা পিতা পূৰ্ণকান্ত হাজৰিকা নাইবা তেওঁৰ পুত্ৰ কন্যা সকলৰ নামে হস্তান্তৰ কৰিব পাৰে। So it is even not at legal heirs of Brajendranath Harika. It is only that to son to the Brajendranath to see Brajendranath Harika or his son or daughter.
Now let us go through the decisions referred by Lord
My lord.
Trial court.
My lord.
Yes.
My lord. I have relied
whether these judgments are available with you.
My lord. I am
Kamala Devi. Oh, no,
my lord, I am having some
Kanta
questions,
Devi.
my lord.
Kanta Devi versus Kamala Devi. And Bharat Singh and Srimati Sumita.
My lord, may kindly look at some decisions, my lord. Kamala Devi, of course, I have not produced, my lord. Kamala Devi, I can produce it, my lord. But some hesitations are there, my lord, which are also relied by the trial court, my lord. My lord, the number 1 is, my lord, page number 5 to 11, my lord.
So first come to this trial court decisions.
Right.
Decisions
171
relied
page.
by trial court.
My lord.
Is available with you.
Yes, sir. Trial court. I'm okay. Trial court. Page 75.
Page
75. It starts from page 75.
75 of
The memo, field memo.
memo 70.
Starts from 70.
Yes. No, these decisions are not available with you.
Trial court.
No. The decision relied upon by the trial court.
My lord, that I told you, my lord. I'm coming to the main issue. Here it starts, my lord, main issue. My lord, it starts from page, actually it starts from page 90.
Issues 85. 84 and 85 issue.
The issue, main issue starts from page 88. Main issue starts from page 88. And the main decision starts from page 91, para 17. Para 17.
Page 91.
The condition number 3 of each number will get it stipulates that in case of any eventuality arising for alienation of gifted land to any other person other than her own son, then the donee, Srimati Gunada Balata, shall have to alienate the same either to Sri Purandranath Hajarika, son of Lord Purnakant Hajarika, or to his legal heirs. That is, it should not be legal heirs, but it is only to his sons and daughters. Legal heirs, my lord, I don't know why appellants are repeatedly writing his legal heirs. It is not legal heirs. It is specially mentioned to his son and daughter. Either Purandranath Hajarika or his son and daughter. Legal heirs is broader term. Legal heirs may be unlimited, but his sons and daughters are only limited to only son or daughter, not the legal heirs of son and daughter. So they are, I don't know why they are using word legal heirs. Legal heirs or not?
No, this word is used in the judgment, not
No,
by
no,
me.
they are also using in the memo bill. They have mentioned legal heirs. It is not legal heirs. I have read the term and condition. Just now the gift deed has been written. Not legal heir, only to his son and daughter. Thus, it is apparently put a limitation upon the donee. Srimati Gunada Balada, or her power to alienation of the gifted property, transfer the same only to son or other of the plaintiff Prajendranath Hajarika or his son or daughter, as such the case may be. But apart from above specified person, a right of alienation of gifted property is curtailed to any other person by virtue of the said condition. However, it is indeed a settled position of law that transfer of property by way of gift postulates for transfer of ownership, that is absolute interest, that the owner must divest himself of absolute interest in the property and vest the same to donee. In the instant case, factum of gift of Schedule D property to let Gunada Balada by owners is not disputed and the said gift is accepted by donee. Hence, once valid gift deed is made to the transferee by transfer, the donee steps into the shoes of the owner of the said Schedule D land. Any stipulation curtailing her right of alienation of gifted property is void under Section 10 of Transfer of Property Act. Those void conditions subsequent has no effect in the eye of law, and the transfer is not bound by the same. Nevertheless, the same some circumstances conditional transfer of property is allowed. Section 10 of treaty states that where property is transferred subject to a condition or limitation absolutely restraining the transferee or any person claiming under him from parting with or disposing of his interest in the property, the condition or limitation is void, except in case of lease where the condition that is section 10. Then para 18. It may be noteworthy to mention in that the rule of repugnancy of absolute extent of alienation of property is based on principle of alienato re something is there, I don't know. That refers alienation is favored by law rather than accumulation. It is based on rule of equity that property should not be made inalienable permanently. Section 10 of PPA deals with annulment of absolute restraint in alienating the property by the owner, which is an essential feature of ownership. Accordingly, Section 10 provides that if transfer is made subject to a condition by which the transferee who becomes owner in absolutely restraining from disposing of a parting with the interest in the condition is void. In such cases, since the transferee becomes owner of the property, any restraint limiting his right of disposing the property would not binding on him, and he would be free to transfer to anybody. However, Section 10 is silent about the situation where the restraint is partial, where the restraint does not take away the power of alienation of the transferee substantially, but only limits it to some extent. The restraint is partial. A partial restraint is valid and enforceable. Nevertheless, Section 10 makes two exceptions to the general rule that conditions absolutely restrain alienation are void. First exception is in respect of lease of a transport of limited interest where the lessor reserves the right of ownership and lessee gets only the right of enjoyment of property, and thus a lessor can impose a reasonable condition on the lessee in regarding the mode of enjoyment. Similarly, second exception regarding property which is transferred to a married woman who is not a Hindu, Muslim, or Buddhist, the transfer can be valid imposed condition restraining till lessor. Then, my lord. Apart from the above section 10 of transfer property, judiciary in India has upheld partial restraint on a variety of grounds, although them cannot be consolidated into definite code. However, I deem it worthy enough to put down some prominent instances where apex court upheld the restriction. Generally, restraining on the term limit within the restriction can be applied. However, taking into exception, Honorable High Court in Loknath Brown versus 1986 Guwahati upheld the condition of restraining being partial restraint. In this case, Gunaram Kolita was in a dire need of money. He sold his property of Foreign Kolita for 1,200 with a condition that the land will be recovered for him after payment of the amount of after 5 years. The Honorable High Court held that it is a valid condition because it is in the nature of partial restraint and is for the personal benefit of the transferor. Similarly, conditions restricting imposed on alienation within the family or community were first declared valid in the case of Muhammad Razak versus Abbas Bandi Bibi, where it was held that such agreement do not go against the spirit of justice. Equally, the good conduct, the validity of such restriction can be attributed to either a sentimental attachment or the preservation of family esteem or integrity within the group. This case deals with the deposition of property and whether Sukra Bibi had the right to alienate property to the appellant. If a condition of transfer is completely restrict alienation of property, then such a condition would constitute absolute restraint and would be termed void. Now, my lord,
On the other hand, on the other hand,
on the same
on the other hand,
if a condition is only partially restrains the right to alienate to property, then such a condition would not be held to be contravention of law and be valid. Then, in the same tune, more recent case of Jorastan Cooperative Society, the Honorable Court allowed for preservation of property within the society to preserve the minority rights inside under Article 29 of the Society. Jorastan Society or a restriction thus imposed on transfer of property outside the community was valid. Another exception, Section 10, is the doctrine of first refusal, which provides the transferor with the first claim over the property, which they are saying first refusal. This implies that if the transferee chooses to sell the property, he should first make an offer to transfer. If the transferor decides not to purchase the property, the transferee can make offer to sell to whatsoever chooses. Devi Dayal versus Ghasita, 1929 SC. The court upheld the validity of a clause in the property transferred that a transferee would first offer to sell the property to transferor and thereafter offer to sell to the transferor if refused. The plaintiff sold the house to defendant for 170 rupees 170 and the latter agreed by agreement to sell the house back to them. Defendant wanted to transfer it and that only if the plaintiff declines to purchase the house, he would sell it to other person. This was a special personal contract between the parties and binding between. So, had it been there in the gift deed, then that firstly I have to offer them. Firstly, I have to offer them in market price. I have to offer them, and if they do not purchase, then I can sell it to anybody. Then it will be parcelation. It will be parcelation. But there is no such thing in the gift deed. Gift deed says that if you want to sell, only sell to this person or to his son and daughter, not to anybody. So, my lord, in that way, it becomes an absolute restraint. If the said person does not purchase it, if the said person do not want to purchase, if the said person do not want to give me specific market price, if that person dies, what will happen? It will absolutely restrain. Suppose I did not sell property to them, they are not offering me market price. I did not sell them. But in the meantime, after 10, 20 years, they have expired. Nobody is there. No son and daughter. Not there. Jannath is not there now. He is expired. His son and daughter has also expired.
no. His
Then
son is there.
Then what will be happening?
I am the son of Brajendranath Hajarika.
That is why I am
and
saying that.
performers are my
That
sisters.
is what I am saying that Brajendranath Hajarika expired. Presently, his son and daughter are there.
Yeah.
If their son and daughter also dies, what will be the condition? I am absolutely restrained. I cannot tell to anybody. So it is whether a condition is a partial extent or it is absolute extent, that has to be looked by the nature of the extent. That has to be looked by the nature of the extent. If there would have been a condition that if you want to sell it, you have to first offer to them. If they do not purchase, in that case, you sell to anybody else. That will be a partial extent. That could have been valid. But here it is absolute extent, either to sell them or not. So and then, my lord, what the court says, my lord. However, the test to determine, now the court has come to the test. Test to determine whether a restraint is absolute or only partial depends upon the effects and not on the form of words lying down the condition. If the effect is absolute, it would be struck off as bad. However, clear language may have been used. The question whether the restraint is absolute or partial is to be gathered from the contents of the deed. The words of the clause have to be so interpreted as to harmonize all the provisions of deed. The determination of whether a condition amounts to a total or a partial restraint depends upon the substance and not on the form. In the instant case, although in the form, the condition number 3 of the impugned gift deed, dated such and such, appears to be partial restraint in alienation of Schedule D property to any other person other than those specified in clause. In fact, in substance, the said impugned clause number 3 of the aforesaid gift deed amounts to absolute restraint upon the rights of the owner to alienate the gifted property. In all those judicial pronouncements, as discussed above, there appears to exist a reasonable nexus between the region of partial extent limiting the right of alienation of property and grounds for validation of the court. But in the instant case, no such reasonable justification has been seen. Necessitated the condition number 3 of the said gift deed, that is suggested, whereby confining the transfer of Schedule D land only to specified person and that too not including the whole family. The family only to family members, only to all the lineage or to the sisters or brothers family, all the family, that is one thing. Here, even not to family members, even specified person. No such reasonable restrictions is done. Hereby confining transfer Schedule D only to specified person and that too not including the whole family. The condition of the said gift deed allows to alienate the Schedule D land only among son of donee, that is let Gunada Baladas or predecessor interest of the plaintiff Rajendranath Hajarika and his son or daughter. However, rest of the family members are excluded. Baki family members, rest members are not excluded. Therefore, unlike in the case of Muhammad Raja versus Abbas Mandi, the analogies preserving family esteem and dignity does not seem to be applicable in the instant case. So now they cannot say the property should remain in family. That is why the condition is made. If it is that the property should remain in family, then it would have been the condition that it has to be sold to the family members firstly. That is not only specified person. There is no reasonable justification for restraining the alienation to said Schedule D property to any other person, including the other family members, other than her own son or Rajendranath Hajarika or his son or daughter, who is the husband of Srimati Urvashi Das, one of the legal heir of statute. Apart from it, contrasting the doctrine of first refusal as enunciated in Devi Dayal versus Ghazi Ram, yes, that said impugned gift deed does not contemplate preemptive offer of sale of the gifted property specified persons mentioned in the clause. There is no such preemptive offer. Rather, it postulates for sale of gifted only to those persons as specified in clause number 3 of the impugned gift deed. Number such as, moreover, if any unforeseen event takes place in future which makes Schedule D property inalienable, such as death of those specified persons, or where those specified persons refuse to purchase the said Schedule D property in future, same would put the Schedule D property in state of installment which is not envisaged in the provisions of Transfer of Property Act, or property cannot remain inalienable, and a condition that makes property inalienable is void under Section 10 of the Act. Thus, in the instant case, what objective to be attained thereby, curtailing the absolute right interest over the state Schedule D property by the state condition number 3 of the impugned gift deed is left unanswered. Having similar fact in the case of Gayasi Ram versus Sahabuddin 1935 HCC online, the Privy Council categorically held that the impugned clause as absolute restraint in violation of Section 10 of Transfer of Property Act 1882. Fact of the said case transpired that the sale deed contained a clause that the vendor shall not transfer the house by mortgage, gift, or sale to any other person except the vendor or his heirs. And if in contravention of the clause, the property is sold, the vendor or his heirs would have a right to get back the house by paying rupees 175. And if the property was to be sold in court auction sale, the sale would be in vain. The sale consideration for house was rupees relying on the Dal Singh versus Kupchand, year 1920 in Allahabad, Askiri Begum versus Mola Bucks, year 1920 in Allahabad, the Gomti Singh versus Anari Kaur, 1929. It was held that the sale deed was between strangers and the clause was an absolute restriction on alienation of anyone except the vendor or his heirs. Therefore, the void in section 10 absolute restriction was there. Therefore, in view of discussion made as stated above and the placing reliance on the judgment filed by Privy Council in the case of Gayasiram versus Tabuddin, in my opinion, the condition number 3 of the said gift that it is hereby limiting the right of alienation of scheduled P property to anyone else rather than son of the Roni or Prajananath Hajarika or his son or daughters amount to absolute extent on right of alienation. Accordingly, same is void under section 10 of Transfer of Property Act. So, the trial court held that it puts absolute extent. Is not if the phenomenon is not bound by the said condition number 53 of said 50 number under such number where the dependent number 3 is not bound by condition 3 of said gift, same is it by section 10 of Transfer of Property Act. Therefore, shall it in December since the stated executive dependent in favor of dependent 2 is valid in the end of law. So, same same issue would be also decided by the appellate court. My lord, may like to see the appellate court judgment also, my lord, on this issue. The same question is answered by the appellate court also, madam. We can see from page 161.
This appellate court has relied upon two cases. One is Kanta Devi, third is Kamala Devi.
My lord, those are decisions relying on the basis that if a condition, if a specific environment is not meant gifted, that condition will be applicable to the legal heirs also. So we cannot automatically say that it will be available on applicable on the legal heirs also.
There
For that
must
one.
be stipulation in the gift
Specific
deed itself.
stipulation in the gifted that the conditions are applicable
Binding upon the
on
legal
the legal
heirs.
heirs also. That is on legal heirs of donee also. That is on that point. Then, my lord, section 10, my lord, also. Section 10 is also entered by the trial court, appellate court, my lord. My lord, it is, my lord, specific findings are from page number 63, my lord. 163, my lord.
Yes.
The defendant
No, that's
in a legal,
in the act itself.
my lord,
Section 10.
my lord. Pardon me. It is under section 10, on section 10, ma'am. Should I read, my lord? 163, page 163, my lord. The defendant in a legal dispute contended that certain limitations are set for gift deed did not bind them as recipient of gift. They argued that these limitations, particularly condition 3, were in violation of section 10 of the Transfer of Property Act as they impose an absolute restraint on the alienation of the property. The defendant maintained that once a valid gift deed is made and accepted by the recipient, the latter obtains absolute ownership of property. Consequently, any provisions restraining the recipient's power of alienation are rendered void under section 10 of Transfer of Property Act. The defendant acknowledged that conditional transfer of property are permissible under certain circumstances. Now, section 10 of Transfer of Property Act stipulates that the transfer of property with a condition that entirely restrains the transferee from parting with or disposing of their interest in the property renders the condition void. This principle is rooted on the legal preference for property alienation over accumulation, undermining the notion that property ought not to be deemed permanently inalienable. Moreover, the provisions specified that if a transfer is subject to a condition that severally restricts the transferee's ability to dispose of the property, the condition will be null and void. However, Section 10 does not address partial restraint where transferee's power of alienation is restricted to some extent. In such circumstances, the restriction is invalid and enforceable with certain boundaries. Notably, there are two exceptions to the general principle. Firstly, in case of lease, that it is in Section 10. Then, para 39. In addition to the above mentioned exception, the Indian judiciary has upheld partial restraint on diverse grounds. Notably, Guwahati High Court validated the condition of partial restraint in case of Loknath Town versus Gunaram Kalida. Here, a restraining limitation alienation with a specific time frame within a specific time frame was found to be valid within a specific time frame. Similarly, a restriction on alienation within a distinct family or community was upheld in the case of Muhammad Razak versus Abbas Mandi Bibi, recognized by alienation to be principles of justice equity. In summary, an absolute restraint on the alienation of property renders condition void, whereas a partial restraint is within permissibility. It is void, valid, and not under law. The first exception, as seen in Jurisdiction Society, Housing Society that I have referred, allowed the restriction on the transfer of property outside the community for the purpose of preserving the minority rights under Article 29 of the Constitution.
So somehow it is not necessary.
So that, then my lord, next page, 166 here, important, it is important, my lord, 166. Para 42. The determination of whether a restraint is absolute or partial hangs on the only partial hangs on the effect rather than the form of the condition. If the effect is absolute, the provision is deemed void. Regardless of the clarity of the language used, the distinction between the absolute and partial restraint must be deducted from the contents of the writ, whether interpretation of the clause aimed at reconciling its provision. It is the substance rather than the form that dictates whether a condition represents a total or partial restraint. While form of condition number 3 of the contested gift deed may suggest a partial restraint on the alienation of Schedule D property to persons other than those specified in the clause, in substance, that clause amounts to absolute restraint on the owner's right to alien the property. If we see it, one can argue that yes, it is partial restraint, they can alienate, but in substance, it is absolute restraint. In the case discussed, a reasonable connection exists between the rationale for partial restraint on property alienation and the grounds for validation of the court. However, in this instance, no such reasonable justification is evident for confirming the transfer to Schedule D land excluding specified individuals, thus excluding other family members. Clause 3 of the gift deed permits the alienation of Schedule D land only to let Gunada Baladas, her son, or Brajendra Hajarika and his offspring, excluding other family members. Unlike the case of Muhammad Razak Abbas Bibi, the rationale of preserving family esteem and dignity seems inapplicable to this scenario. As they have argued that family property should remain in family, that is not the case. Here, only specified persons. Furthermore, in contrast to the doctrine of first refusal in Devi Dayal versus Dhasita, case clause number 3 of the contested gift deed does not contemplate a preemptive offer to the sale of gifted property to specified person, but rather mandates its sale exclusive to specified. Preemptive sale or kotha nahi. It is not a matter that firstly I have made to make offer to them. That is also not the same finding of the appellate court. Moreover, any enforceable in the future, if such as death of specified individuals or their refusal to purchase the property could render the Schedule D land inalienable, contrary to the provisions of the Transfer of Property Act, as property cannot remain inalienable in any condition leading to such a state is void under Section 10 of the Act. To put it simply, a conditional gift deed where donee must transfer the property designated recipient is regulated under Transfer of Property and the Indian contracted in India to be deemed valid and condition must be lawful, clearly stated and contingent with legal provisions. Similarly, to adhere Supreme Court rulings such as Mohanlal versus State of Maharashtra, Ram Babu versus the legality of those which conditional gifted has been affirmed contingent upon the conditional legality of the transfer. Failing to meet this legal criteria may render the gift invalid and such subject to potential revocation.
Okay, Mr. Sarnoff.
So this is the provision, my lord. The condition is that but my lord, this is not a mane, question of law, substantial question of law, because the law is clear. You cannot put absolute restriction on the property transfer. So Honorable Supreme Court has also said that you cannot absolutely transfer the restriction transfer. Only thing is that applicability of provision that is not a substantial question of law. Applicability and apart from this, my lord, in this case, on bare perusal of the gifted, it appears that if the condition is absolutely unjust, it says that if you want to sell, you sell only those persons, not any other person. It is not even mentioned that you can sell it to a family and it has to be sold to family members only. There is no condition that you have to make first offer to them. As they said that the first offer has to be made to them. There is no stipulation that first offer has to be made. The stipulation is you have to sell them. Whether the purchase or not, if you want to sell, you have to sell them, not to any other person. That is absolute extent, my lord. So, my lord, I have submitted citations, my lord. My lord, may see the citation. Firstly, my lord, year 2008 Kerala, my lord, page 11, my. Page number 5 to 11. 5 to 11.
This is it.
Here, my lord, I have marked the specific portions relied by me, my lord. Specific portions relied by me.
Page number?
My lord, the specific portion marked by me are page number 7, page number 8, 9, and 10. Page number 10, my lord, page number 10, para 14. After discussing all the various decisions of various high courts, my lord, say that Agreement 42 does not contain a specific clause prohibiting respondent from alienating the property to third party. There is an implied clause that in the event of failure to construct a college, the property shall be conveyed to the assigner at the same price, thereby shutting out any other option. It is an absolute restriction on the right of the respondent to deal with the property, including alienation, which is void as provided under Section 10. It also provided that if you cannot do such a things, you have to tell it back to such a person only. That is held to be absolute restriction.
Okay.
Then, my lord, next, my lord.
Is the part.
Next, my lord, yes. Next, 12, my lord. That page number 12, my lord.
Yes, relevant paragraph.
Relevant paragraph. Relevant paragraph is my lord. Relevant paragraph number 38, 39, and 41. 38, 39, and 41.
Yes.
My lord. Year 2016, Delhi.
Next judgment.
Next judgment is 1935 Allahabad, my lord. That is
Page number.
that is page number 32 to 35.
Paragraph
32 to 35. It's paragraph number 6 and 8. Para 6 and 8. It says that on the other hand, I consider that there are three rulings in which the principle has been laid down in favor of defendant. The first this ruling is Dal Singh versus Bhutchan Singh. Here also it is stated if there is absolute justice, there is absolute restraint. And what is absolute restraint? That has to be that how we can consider a restraint to be absolute or partial. It is discussed in para 7. What is the absolute restraint? What is partial restraint? As similar finding is by the trial court that it may seem to be partial, but it may be in fact absolute restraint. So how to decide if whether it's absolute or whether it's partial? That is decided in this decision, 1935, my lord. Then, my lord, page 36 to 40, my lord.
paragraph number
Paragraph number. Is my lord. 9, 10, and 11. In this case, it is stated that even in case of family settlement, absolute restraint is void. Even in case of family settlement, they are saying that is family matter. Even in case of family settlement, absolute restraint is void. Then, my lord, page number 41 to 44, my lord. Page 41 to 44.
relevant paragraph.
My lord. Relevant paragraph will be my lord. Paragraph 4 and 5. Paragraph 4, 5 and 6. 4, 5 and 6. 4, 5 and 6. It also says that in order to see whether there is absolute restraint or not, one has to examine the effect of all the conditions, as in by the trial done by the trial court and first appellate court. One has to examine the effect of all the conditions that find out whether for all practical purposes alienation is prohibited. Mere remote possibility of alienation cannot take case out of the restraint. Where remote remote possibility of alienation cannot make the case out of the restraint. There is very remote possibility. They may purchase or may not purchase. So it has to be seen.
Okay, next is the Supreme Court decision.
My lord.
Regarding second appeal.
My lord. Regarding
section 100.
Section 100, my lord. Section 100, my lord. Actually, that is, my lord. Whether, my lord. My lord. Then the thing is that concurrent finding of fact. In this case, concurrent finding of fact is there.
Okay.
My lord. So
next decision.
So whether the court will interfere, how the court will interfere in the concurrent finding of fact, my lord. And then is AI 20 Supreme Court, my lord. That it says that the owner imposing restriction on alienation of property gifted in favor of minor has no application as property was gifted for unborn person. Certain conditions or restraint, condition restraining alienation is void. There is, in this case also, there is a condition restraining absolutely the transfer of the property. The Supreme Court said that the condition absolutely restraining the transfer of property is void, and it is also relied upon. The same case, this case also relied upon AR 1939 Allahabad 221, which we have also relied, my lord. With the trial court and first appellate court has relied AR 1935 Allahabad, which is Devi versus Srivastava. So, on relying on 1939, the Supreme Court tells that no, absolute restraint is void. So, it is a then this court says, in this decision, court says, this court has only taken the view that condition restraining donee from alienating the gifted from gifted cannot be imposed and such a condition is void under section 10 of the, I respectfully agree with the view taken by Rich Devi Supra. So this is settled law. Supreme Court has said that there cannot be absolute restraint. So if it is a settled law by the apex court, then in this regard there cannot be substantial question of law. Already a settled law. So now only how the question of law had been applied, application of this question of law, that cannot be a substantial question of law. How that law has been applied, that cannot be actually substantial question of law. That is the factual position on which the court has come to a final conclusion. Both the court have come to the same conclusion. There is a concurrent finding of fact. There is no illegality and infirmity.
Okay.
So there is no substantial question of law at all involved in this appeal, my lord.
Okay. Yes, Mr. Thakkar.
My lord.
Any reply?
Yes, my lord. First of all, my lord, I would like to take your lordship to why that condition was and whether it is a absolute restraint or partial. Page number 30, my lord, of my memo of appeal. Page number 30. Page number 30 contains condition. Page number 38 relating to that matter. Page number 38, my lord. See.
Yes.
My lord, the last schedule is Schedule D, wherein, my lord, in the west side, Brajendra Nath Hazarika and late Keshav Datta's land and house is situated. That is Schedule C, my lord. And in Schedule D also, your lordship will be pleased to see that in the eastern side, land and house of Shri Brajendra Nath Hazarika is there, my lord. My lord. So that was one of the reason, my lord, that in the two of the sides, Brajendra Nath Hazarika, and after his demise, Dr. Jayanta Hazarika is residing therein. So that was the condition made therein, my lord. One aspect. Second aspect, my lord, my learned friend is saying about the absolute restraint. Your lordship should judge whether the condition number 3 is in anticipation that condition number 3 entails about absolute restraint or partial restraint. That is to be. My lord, for that purpose, on section 100, lastly, your lordship has asked a question on section 100. My lord,
No,
I will
Mr.
take
Thakkar,
only one line.
Regarding section 100, it is well settled.
Yes.
In respect of concurrent finding of facts, the High Court cannot interfere.
Definitely. But my lord, when the Honorable High Court can interfere, my lord, kindly.
No, there may be absolute perversity. When there is absolute perversity, is there
Then the
any
Honorable,
perversity?
then the Honorable
That is
Court
in
can
respect
interfere.
of fact. You have
Yes.
shown it.
No, but it speaks about the document, my lord, not about the fact. Held, my lord, last paragraph. Held, it is now well settled that an interference of fact from a document is a question of fact. First page, my lord, last paragraph, first page. But the legal effect of the terms or a term of a document is a question of law. That term, which is incorporated in clause number 3 of the gift deed, my lord, it speaks about a question of law. Construction of a document involving the application of a principle of law is a question of law. Therefore, when there is a misconstruction of a document or wrong application of a principle of law, while interpreting a document, it is open to interference under section 100 CPC. This is my last submission before the Lord.
Third Mr. A. Satsar, learned counsel for the appellant, Mr. Sharma, for the response. Argument concluded, order is there.
Well, one completing one more picture. Recent judgment which was passed was about regarding the when the court did can be revoked. That it said that if there is special condition, then only it can be done. So there is similar case. If there is specific condition, then only it can be go to legal. By response.
Very